Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
G'day, good morning, good afternoon, good evening, good night, good day, wherever it is you're coming from. Let your boon run free, because today is the day. I can feel it in my waters. Welcome to the Defence Rest. I'm Jody, and today, after nearly 5 long years, it's finally arrived. It has. We have a jury. They are seated. Good morning, Tina P. Welcome. Welcome. Thank you for joining us. Thank you very much. And Teresia, good morning. You're not holding your breath. I have said that for the last nearly 2 weeks. I don't think there is any other possible delay that could happen. We've been through everything. But I do have a theory, actually. I don't know if anyone saw my short today, but I have a theory. And to me, it makes sense, even though I don't know a great deal about the US justice system. I know enough, but I'm not by any means a lawyer. But just as a common sense aspect, and me having a brain that doesn't stop working whenever, yes, my thoughts have taken me to a place where I actually think if they play their cards right, there is a chance that she could walk for time served. And I'll explain it to you. I will go through it, don't you worry. Because we've got half an hour before the trial is set to start. Actually, no, we haven't. We haven't got that long at all. It's still counting down. Woo-hoo-hoo! Every day this week I've been watching, and they just change the time and date on you without even notifying you. But anyway, we are going ahead today. Now, welcome, and thank you again for joining us. Happy Funky Friday. Yes, we made it. Another Friday. Okay, so bear with me on my theory. Where is my notes? Okay, so we started off at the beginning where Sarah claimed that it was all accidental. Okay, it was not intentional. Good morning, Christine. Welcome, welcome, welcome. I'm just going through my theory on what could happen, and the way that I have analysed it in my head, if I'm correct, I don't think they can get past manslaughter, because I had a look at the Florida statutes today and went through them all, and there's a lot of things that are combined in this battered wife syndrome, which is allowed to come in. Yes, yep. 9 o'clock it's going to start, but the feed countdown is on at 4 minutes, so I'm assuming they're going to open the cameras then, but there'll probably be no sound or anything. They'll just be setting up. So, as we know, she's changed her defence strategy 3 times. The first one being accidental, which happened right at the start when she was interviewed under the body cam and in the interrogation. Didn't mean it to happen, you know, a whole lot. But in her defence of that, the only thing that she could really provide was that she was intoxicated and it was an accident. Now, involuntary intoxication in and of itself is not a defence, so that's risky. Good morning, sorry. Curly, are you from Twitter? Is this Jane from Twitter? Another Melbourne gal? Welcome, welcome, welcome. Smash that like and subscribe, sweetheart. Smash it. I'm 78 peeps away from getting monetized. 78 double digits. Woo. Go me. welcome, and thank you. Um, it was a ridiculous afternoon here. The rain just pelted down, and now it's really humid, unless it's just me going through menopause. So I've got the fan on. Could be both, but welcome anyway. Excellent, good job. Thank you very much. My mum rang me this evening and asked me if we had hail, but I didn't see any. So, and mind you, I haven't watched the news and I haven't been outside either, so been too busy researching. Okay. So, the first one, accidental. The voluntary intoxication isn't a defence, so it could stay at second degree murder. The second one was her self-defence. But with a self-defence you need to be able to show an element of intent. And that could be argued by the state almost as premeditation. So it's again too risky a strategy for her. So what I think they've come up with now, with either James Owens is a genius, or he has stumbled upon something that he is not actually aware of, or I've got everything arse about. Could be one of the three. So in Florida, what was it? Oh, no, let me go into the battered wife syndrome. All right. So the battered wife syndrome defense encompasses a couple of things. It encompasses the self-defense aspect, but it also covers the domestic violence aspect. So with a battered wife syndrome, there needs to be, and what you would have seen in the motions hearing was the judge trying to, or the state trying to establish that there had to have been a trigger, like an act of provocation for this defence to work. So she would have had to have been provoked or triggered in some way to create the feeling that she is in imminent danger of grievous bodily harm or death. Now, not only that, bear with me, because the incident happened in their home, she also is covered under the statute, under the duty, she is covered under the home protection and use of deadly force under the presumption of fear of death or great bodily harm. So she doesn't have a duty to retreat. Okay, so if they're claiming this syndrome and they, how do I explain it? So let me go back to the start. The video that she created with George inside it begging for help, you can clearly hear that she is extremely intoxicated. And as I said, whilst that's not a defence in itself, it could potentially be used as not a symptom or a treatment or a way of coping with the battered wife syndrome. You understand? So she's using alcohol as a crutch. So her alcoholism could be attributed to this battered wife syndrome. All right, so that's the first step. Now, if you see that video and clearly he is calling her name and saying he can't breathe, Sarah, 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 and you can clearly hear that she's intoxicated, that goes to her state of mind, her ability to make conscious and rational decisions, because to get to second-degree murder, the prosecution has to prove a depraved mind. How can you prove a depraved mind if it is so intoxicated that it's unable to be assessed at the time? No one was there to assess it. Her blood alcohol was never taken, so we don't actually know the extent of the intoxication. And again, she is using the alcohol as a crutch. This is just my theory, so you don't have to agree with it, but I'm just trying to put it out there that I think there is an actual argument in this battered wife syndrome, and the fact that the defence have been putting all these motions through right at the very end, it all sort of clams together because they have to establish that defence pre-trial. And the judge has said that they can't get in any extra evidence unless it was to prove the provocation point, so to speak. Now, she has plenty of evidence and testimony from her ex-husband, Brian, who has stated that, yes, they had a volatile relationship. Yes, she has a history of alcohol abuse to the point where she does pass out and can't be woken up multiple times on the phone. Rung, he's tried, and she's been late, and so he's established a pattern of the alcohol abuse. Okay. Now, they want his medical records to come in. Why? Why? Because that then backs up the cycle, the history of abuse, because apparently a lot of the medical records are him injuring himself from losing his temper, punching walls and stuff. Hey, Debbie, good morning. Good morning. Welcome. I'm just trying to explain my theory here, and I'm not making a very good job of it. But so they have to prove intent, and they have to prove a depraved mind to get to second degree. Now, if she continues with this defence, she can show that the state are going to call the ex-husband, and under cross-examination, the defence attorney can question him about this history, this cycle of abuse, and that will then further bolster this battered wife syndrome. Now, they're not allowed to bring in any new evidence, but the defence have said that they may call the ex-husband on to testify on their side, which will then they can go further and go deeper into their case in chief, and because he has experienced their volatile relationship, and he has been able to establish this cycle and this pattern and this alcohol abuse. So if they do this battered wife syndrome, it addresses the alcohol issue. It addresses the state of mind, which then covers intent, premeditation, and there was a third one. So basically, they can use the state's whole case in chief against them. I'm not explaining it very well, sorry. Let me read what I've written. So, battered wife syndrome, it clears up the voluntary intoxication issue, okay? So it converts it into a symptom of the syndrome instead of it being on its own an issue. So that symptom it's a symptom of the battered wife syndrome because that's how she copes dealing with it. That's the first point. So that's part of her coping mechanism as a battered wife. It also goes to establishing her state of mind and her altered conscious state, obviously, in decision-making process. Secondly, it removes the intent element from it because she is drinking to excess. It was a regular occurrence, so we can establish a pattern with whether it's on cross-examination from the or the defence calls it up. And his testimony will be pivotal. It will be what the case relies on. That's what I'm predicting. Okay, so he claims that it wasn't unusual for her to get drunk and pass out all the time, and not be able to be woken up, and misses deadlines and appointments with her son, a visitation, all sorts of stuff. Okay, it further adds to the pattern of behaviour attributed to the ongoing abuse. And the video itself has Sarah stating, so every time he calls out Sarah, 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 she is reiterating, that's for everything you've done to me. Okay? That's for every time you've choked me. So she, in her mind, is recalling prior events. Okay? So that could be used as the triggering point for her. So there's the two videos and there's a few minutes in between the video. She will take the stand. She has to. She has to take the stand to lay the foundation to be able to have this plea, have this defence. Okay, she has to lay that foundation. The only way they can bring in those records of the domestic violence history and stuff is through her. It can't be rebutted because he's not here anymore, but it can be backed up by the ex-husband with the cycle of abuse, and then with the cycle of, with all the evidence of the domestic violence charges that both of them had, that type of thing. So that then bolsters that again. Then all he would have had to have said to her, she can get up and testify because there was no other witnesses, and all she needs to say is, when the camera wasn't on and after I'd gone too far and I realised I'd gone too far by hitting him with the baseball bat and doing all this other stuff, and because we know he had blunt force trauma as well, he could have said to her, just you wait until I get out. That could be, because as we know, witness testimony is evidence, that could be what her trigger could potentially be to set off this battered wife syndrome, for her to then feel that she is in imminent danger of grievous bodily harm or death if she lets him out. Does that make sense? She's covered then by the statute because she doesn't have to retreat. The prosecutorial immunity also states that complete immunity for defendants whose use of force meets this criteria is a person who used force as permitted by the statute, The term immune meant that if the accused could factually establish pre-trial that his or her use of deadly force occurred under the circumstances outlined in this particular statute, which is what I said about the duty to retreat and the home, protecting your home, then the state of Florida would be legally and procedurally barred from further prosecution in the matter. All right, so there's that one. And then the stand your ground law, that also comes into this battered wife syndrome. Okay, so it provides potential immunity from prosecution for an accused person whose actions are shown to fall within the provisions of the statute. the potential for immunity marks another significant departure from the self-defense claims at common law. So, the common law in Florida offered no remedy by which a defendant could pursue immunity from prosecutions on the basis of a self-defense claim. So, we're not doing self-defense claim. The question of justifiable self-defense was a factual question that the jury is to resolve at trial. The jury being the fact finder and the decider of whether it was sufficiently justified to insulate the accused from criminal liability. Now, all they have to do is create doubt. Yeah, they don't have to. It's the prosecutor's job to prove beyond a reasonable doubt and meet the criteria of second-degree murder. And that means they have to prove the intent, they have to prove the depraved mind, they don't have to prove premeditation, that's first degree. But the fact is, if they play their cards right here, and they can actually use the state's case against them in my head. So, you know, she's reciting things like, for all the things you've done to me, for every time you choked me. The prosecution will put that across as a depraved mind act because it sounds like she's going through revenge. But if you pivot that and turn it around, it could be used as her recalling prior events and that cycle of abuse, therefore triggering this battered wife syndrome. Does that make sense? I'm trying to explain it as best I can. This is my prediction of how it's going to go. So it also reaffirms her explanation to law enforcement that she passed out because she can prove that she has a history of that with the ex-husband's statements. They'll argue that, that's the other thing. They have to, how are they going to prove that she put him into the suitcase? I don't think that she's physically capable of putting a grown man, even though he's only 100 pounds, into a suitcase and zipping him up without any consent from him. I believe that he actually put himself in there. Yes, she zipped it up, but where does that stand? If it was premeditated, she couldn't have forced him in there. Do you understand? Then, where is it? Yes, so her ex-husband can testify to all of her prior episodes of fighting and abuse in the toxic relationship, and back up Sarah's actual testimony, which will be evidence, and he will provide that key. He'll provide the key for her to get a manslaughter charge, a voluntary manslaughter charge, and that's where I think this will end. I think that's what, in my mind, I think the evidence, unless something new comes out, I don't think they can go any higher than voluntary manslaughter. Now, second degree murder is 10 to life. She refused the plea deal last week, which was 15 at 9.75. So 65% worked out to be 9.75 years. Less time served was 5.75 years. What do you think the minimum sentence for manslaughter in Florida is? 4 years. Now, was she smart to do that, or wasn't she? She's banking on a lot, but technically, she's already served 4 years. Are you hearing me? Just let it process. Just let it process. If they charge her with voluntary manslaughter, she could basically to walk with time served. Does that just blow your mind? because, yeah, it kept me up last night. So, what have I got last here? If the death arose out of an intense emotional response, but still required some intent to unalive, what's that? Well, I can't read my own handwriting here. All right, so voluntary manslaughter is the unaliving of someone without the intent, despite the presence of the harm or death. Okay, it's a second-degree felony, and I think it's between 4 and 10 years. So even that is less than what she was offered. And as I said, if it rose, it can be proven, like voluntary manslaughter, if they can show that the unaliving arose out of an intense emotional response caused by battered wife syndrome, case closed. They can't go any higher than manslaughter. Sorry, chat, I have missed everything. We go way, way back. All right, Curly. I personally think that night she absolutely was off her face. And it does sound like revenge talk. But if you spin that, okay, and you add the fact that the alcohol abuse was a symptom of her coping with this syndrome, okay, and the fact that she is reciting the things that he has done to her previously, you can spin it. You can spin it to battered wife syndrome. You can. Good morning, Debbie. Good morning. Welcome, welcome. Hello, she loves rats. Hello again. Welcome. I love cats. You love rats. Sounds like a Dr. Zeus. Owens wants to question Brian about this. Yes, that's another one. Okay. When I was watching the motions hearing yesterday, I actually questioned it too on the live stream, saying, "Why does he have to pay her money for alimony?" Right? Okay. His refusal to pay alimony to her is an additional it's a type of domestic violence by financial abuse, by taking control of the finances. Okay, so as part of a domestic violence situation in that bubble, part of that can be financial control. The other part can be, parental alienation, where you're telling the child, oh, dad's an idiot, he does this, he does that. That all is encompassed in domestic violence, which is encompassed under battered wife syndrome. Yeah? Yeah. All right. I think as soon as they show the video, she's done with, to be honest. Even if they tried the battered wife defense, she has no immediate danger. Well, if they can say, if she gets up and testifies and says that he stated that he was going to harm her if she let him out, then that changes everything. It completely changes everything, because that's her trigger, and that is her way where she can say, I had an extreme emotional response because of my previous cycle of abuse and battered wife syndrome. It all can come back. It all gels together. She has no immediate danger. Well, in her head, has she? She's that intoxicated. Her ability to be reasonable is impacted. Yeah. Just have a think. I could be barking up the wrong tree, but it's an aspect I think that we can't ignore, because she also said they were having fun. That was the first one. That was the first claim where she was saying that they were having fun and it was an accident. But she's changed her defence strategy since then. She's changed it from that to self-defence and now battered wife. And the reason you change it from accidental is because you can, the prosecution can still then address there's an element of potential intent from her statements whilst he's in the suitcase and contribute that to the depraved mind, and that then meets the criteria of second degree, which is what they have based their charges on. But under the battered wife, you can have times of fun and times of violence and times of toxicity. It's a cycle. Okay, they need to prove the cycle of abuse. Exactly, Kelly. There was no danger there, and then but it's her perception of the danger. It's what she thinks in her head, what she perceives. Can you, if you're that drunk and you're already starting to feel anxious because he is triggering you, and you're remembering things, and you're saying, "That's for all the things that you've done to me. That's for all the times you've choked me." So you're already starting to have this turmoil in your head. And then what happens if he says to her, "Just you wait until I get out of here. I'm going to beat the crap out of you." Yeah. Does that make sense? I don't for a second agree with her behaviour, her actions, her whatever. I don't agree with any of it. I don't even like the woman. But I'm looking at it as a legal perspective and under the Florida statutes. And I tried to work out why they are pushing so hard for this battered wife syndrome defence. And this is the only thing that connected all of the dots for me. I'm hoping there's more videos. I don't think so. I think there's only the two. And in between the two, apparently she has admitted to hitting him with the baseball bat. And that's how he got all of the blunt force trauma, which the ME will testify to. But again, that could have been after he made a threat to her from inside the suitcase. It could be 5 words to trigger this extreme emotional response that can be attributed to this, because it's not just a black and white line. This battered wife syndrome is an umbrella encompassing a whole heap of shit. All right. Anyone can get out of this. Yeah, absolutely. Absolutely. And that was where I started, because having 8 alternates, that judge ain't taken any chances of having to do this again. And so I started going down the technicality route, and this is where I ended up. Yes, she did beat him with a bat. Yes, she's agreed with that. Yes, yes. And again, it can all be attributed if it depends on her ex-husband's testimony and her testimony, because who's going to, there is no one that can argue that he didn't say that. Yeah, no one else was there. And once she testifies, that testimony is evidence and is admissible. I'm sorry to say, ladies and gentlemen, but that is a fact. Yes, they did say that emotions. Yes, yep. Do we know what? I'm watching the live stream now. It is, they have on the live stream coming up, day 1, opening statements, Florida versus Sarah Boone, suitcase murder trial. But we've got the seal. That's it. I have my eye on it, trust me. I personally don't see her walking. Going to be an interesting trial, nevertheless. Yes, absolutely. And this is what gets my brain turning. The strategies involved in this. When I said walk, I meant get off on a lesser charge that is less than the plea that she rejected. So if they can prove defence can prove, because all they need to do is create reasonable doubt, remember? If they can get that down to voluntary manslaughter under this battered wife defence, the term of punishment in Florida is 4 to 10 years, minus time served. So she really had nothing to lose at the end of the day, if they can do it. If they can do it. Yes, she zipped him in, but she also said that she left enough room for at least 2 fingers, apparently. Yes, she rolled him over. It didn't matter what she did to him, because if she has been triggered and this extreme emotional response to the syndrome has been triggered by something that he has said or done in the suitcase, that all goes. That all goes. It all goes. Yes, yes, I did. Yes, I did. They were playing in hide. Yeah, exactly. Exactly. That explains how he got into the suitcase. So I believe he voluntarily put himself in there. There's no way she could have done that. So where does that leave her defence? How does that affect the prosecution? They can't say that had intent or premeditation, then that takes that off the table. If he voluntarily got in there himself, he can't, in my eyes, prove that. Oh, there is a Netflix. There is. Apparently, she has signed paperwork. Apparently, on the grapevine, there is definitely Sarah's case. Yes, I'm not following it as such. I'm streaming it overnight, so I'm sleep streaming it. So I run it without commentary. We're up to day 10, and I don't know how long today is going to last. So I normally run it straight after my live stream of an evening, being Melbourne, having to stream live, real time. It's midnight here when court starts, so I don't know what time I'll be finishing up. So I thought that I would just run it over the weekend. So day 10, I'll run on Saturday, and that'll give you something to watch. But that looks really, really interesting too. That looks really interesting. And Teresa thinks she looks like the Grinch. Totally get that, Jodie, when it's all going through her head. But then she went to sleep. Yes, but she was so intoxicated that she passed out, and she can prove that she has a history of that. Yeah, that comes in with the ex-husband. That comes in with the ex. Hello, Uda. Good morning. Good morning. Well, it's not morning for you. It's late morning for you. You're normally up sparrow fart. Or evening, yes. Yes, well, it's actually morning here now. It's 12:15. We have another extra Aussie in the house. Curly. Miss Tracia. Curly Udahef is one of our stars of the channel. He lives in West Palm Beach in Florida, and he came on during the live stream that I was doing with Hurricane Milton. So if you check out on my playlist, you'll see his gorgeous, gorgeous face on the screen. Boss just called and asked me to. Oh, always the way. You can't. It's Boone Day. You cannot do anything. Take a sickie. It's Boone Day. Now you got me worried. Yes. Yes. There is aspects there that could potentially justify this use of deadly force. Yeah, Aussie, Aussie, Aussie! Oi, oi, oi! Who'd have likes what is it? The Pauline Hanson. I don't like it. Don't like it. There was another one that she said, and I can't remember what it is, but I'm sure he'll remind me at some point. Right, so now, seeing as it is a Moon Day, why? Wow, which one should I do first? Should I do? No, let's do the song. All right, let's do the song. Jodie got a little bit creative and typed up some lyrics with an AI app and made a little Sarah Boone theme song. All right, it's going to be played every day of the trial, so I've been singing it all day. So enjoy, have a laugh, and go.
So my name is Sarah Boone, and I'm on file for my life. And my defense in this darn trial is that I'm just a battered wife. My boyfriend George and I would drink and end up in a fight, till a game of hide and seek caused massive changes overnight. You see, we had been drinking wine, and I was probably off my face. And my boyfriend thought it cool to put himself in a suitcase. When I zipped him up inside, he started calling out my name. So I recorded what he said, cause I thought he was so lame. I was so drunk that I passed out, woke up with a thumping head. And when I opened up the suitcase, I found my boyfriend who was dead. Now they charged me with his murder, and I've been locked up in this jail. And my fate may be decided from my recordings of his wail.
Yee! Banjo solo. If you haven't worked it out, I've got a sixth sense of humour. Why is it wine?
At first I claimed an accident, and in my statement I would say that the game of hide and seek was what we both wanted to play. And then I got some useless lawyers that were really effing dense, and they refused to change my claim to make it out as self-defense. So now I'm on my ninth attorney, and 5 long years has been a while, writing letters to the judge while I've been waiting for my trial. So when James Owen saw my ad and chose to help me save my life, he then put forward a new motion to claim defense for battered wife.
Battered wife. One more verse.
So let's see who has the power. But I might stick during the trial if I don't get a doggone shower. I want my chippies and Pop-Tarts and a box of cookies too, and maybe add to that some water and some peppermint to chew.
Oh, ta-da! I know, I'm an idiot. And I have the weirdest sense of humour, but hey, that's why you're here. That's why I don't get the big bucks. You yesterday. I have been singing it all afternoon. You have to know the aspects of the trial to truly appreciate it. I did put it on Twitter. I made it. I wrote it. And I put in the genre, and yeah, it came up with the tune. I put in banjo, folk, funky folk, country western, I think, and that's what it spat out at me. I'll put the link for the app. It's free. In the chat. You just Google it and you get 50 free credits, which gives you, I think, 10 or 5 creations, 5 a day. So you can, give it to me. Oh, Oh, we have movement in the court, peeps. Movement in the court. Hang on. I'm going to turn this fan off because now I'm bloody freezing. Oh. Okay. Come on, Jodie. Pull up here. I have a big following onto you. Yeah, absolutely. Knock yourself out. Do you want me to put I can post the link. Well, it's on Twitter. But I can certainly put it in chat. No worries. All right. Shall we share this? Share this screen, and let me make it my personal touches. Where did I save that? Background. And we have Court TV. So Court TV openings. Ah, look. Ain't that pretty? Yeah. And look at that. We're ready to go. Ready to go. I also did a I did an ad. Good morning, Elizabeth. Hello. Welcome to Boone Day. Drum roll. Are we all excited? Are we all excited for this to happen? Yes. All right. Oh shoot. Good on you, Jodie. Idiot. Let me share. Oh, hang on. I will find this ad. I don't know why I didn't click it before. I thought it was already on there. There it is. That one. And now, share screen again. One, share. At stage. Okay. This is the a word from our sponsors. Okay. And go. Hello and welcome to our suitcase mega sale. We have lots of different various colours available for you to choose from. We even have a replica vintage selection. You can choose inner lining as an optional extra. And they are perfect for travelling. We also have both new and used models in stock, but no returns on the used. Oh. They all come in a variety of different shapes and sizes to suit your needs. And you can choose between a hard or a fabric outer surface. But wait, there's more. If you order now, you get a free roll of crime scene tape, but no extra. But only while stocks last. Oh, excuse me. So there you go. And yes, sorry, I didn't. Elizabeth, what can I say, darling? I'm really, really sorry. That is fucking awful. I am a nutter, yes. I am a nutter, absolutely. But yeah. You do never have to apologise that you haven't been here. There is no obligation. And you probably need therapy once you leave. So don't ever apologise for not being here, ever. We appreciate every second. But that's awful. Awful. And I'm really, really sorry. My heart goes out to you, sweetheart. It really does. I don't like hearing that. It puts everything into perspective, doesn't it? So, sending big love across the waters. Big love to you and to their families. Oh, we have noise. Noise in the court. Were they old, Elizabeth? Like, oh, you're very welcome, sweetheart. Whoop. Loony Boonies in the courtroom. What rhymes with shackles? Could have put that in the song. Were they expected, Elizabeth? Were they sudden? Like, because you're only young. It's awful. Well, you've just convinced me to spend the $500 that I've been humming and ahhing about to go and visit my mum over Christmas up in Harvey Bay. So I'll be booking those tickets tonight because she hasn't been well either. So I know I'll regret it if I don't go. So, yes, thank you for convincing me. Little Miss Prissy, shoulders back, sit up straight. Don't mind your P's and Q's, because you can't.
Bless you.
I really do like this judge. Really, really do. No bullshit, no nonsense. I wouldn't be smiling. Or would I? One of them has to wear week before. Oh, fuck. What was the surgery to try and remove the cancer, or where was do you know where the cancer was? Where the primary started, or? Sorry, I don't mean to be nosy. If I can help explain possibly the complications of surgery, then I'm happy to. Oh. And the one that passed away, who does?
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
Well, they would have to do an autopsy. They would have to. At that age. And that, if that
Good morning.
is
Can you please
sudden.
state your full name and date of birth for the record for me?
Sarah Boone,
Oh,
10-10-77.
absolutely.
Ms. Boone is seated
Absolutely.
at counsel's table, wearing a black suit and a pink
Yep.
blouse. She is in custody in this matter.
Pink
However, there are no
blouse?
restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 is
Look at the
identified in the
boxes of fucking
defendant's
evidence.
fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of that deal with just billings, observations.
What's that? So, where was the large mass? Was that? It sounds like it wasn't on his kidneys. But stage 1 is quite early, so he would have been booked in for either chemo or radiation for the cancer. But where was the mass, and did, because what can happen is the mass could have been the primary site, and what happens is it's it's like got octopus tentacles, and it's called metastasizing. So it spreads to different parts. So the kidney part could have been like secondary to the mass, so to speak. The mass is, do they know if that was, do they know yet if that was cancerous? Like, because it's just awful, Elizabeth. I'm really sorry. And we can we'll come back when they have a break, and we'll have a good chat about it. All right. I'm really, really sorry. Massive, massive love to you. You have the strength. You can do it. You can get through it, my darling.
The medical personnel don't necessarily apply to the issue of anxiety, as the court had indicated.
Okay.
I did include certain pages that discuss depression issues, as I believe that they were related to anxiety.
Can you hear
And
that?
I've identified 4 or 5 other pages that are not anxiety related that may be relevant to the case. I've described that.
Of those 119
Whoa.
images, how many are being sought? 15? Okay, thank you. State response.
Is it?
Apparently, these are all just related to a January 23rd.
That bit better, because the judge came through loud and clear. He's got a mic. They've got a mic at the stand. It's the defense attorney who stands up, who's so tall that the distance between him and the mic makes him very, very quiet. And I've got it boosted bad. And when the judge spoke, it nearly blew my eardrums.
2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I had to, I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for.
A but for.
The fact
There's
that
a but file.
at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least 1 medical doctor, well, 2. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologists will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that.
So does that mean they did do a blood draw on that first day when she called 911 on the 25th? Because I didn't realize that they had a BAC. So her BAC was 0.16 at after 1 o'clock the following day. So can you imagine how intoxicated she was the night before?
Page 29 is another page
And
they listed.
this is the Richardson's hearing, I think. Or the finality of it. I think we're waiting for his ruling. And the Richardson hearing was to address discovery violations.
That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included.
January 23rd?
Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48 and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
That would go to her
What's 49?
ability to metabolize the
So
alcohol.
seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described.
So if you embrace what I've explained under this battered wife syndrome and what it encompasses, the inclusion of her height and weight by the state can be used against them because it goes to her stature and her ability to get him into the suitcase. Yeah.
Described as page 26, because part of the results on page 49 show that she was
Bless you.
tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete. And
But they are also seeking 49, correct?
Yes.
Thank you.
Just they just skipped 48, just like they skipped 26. Page 63. It appears to be
I bet
repetitive. but we
I
don't have
bet
any-
you any money it was Sarah that didn't want her weight to be known. I guarantee. Simply because of the way she behaved with the sizing of her jail uniform. She didn't want a medium, she wanted a small. So she would staple them tighter. I betcha that's why she didn't want that page in.
particular objection, page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So I basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 Southern 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. And I think it was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from or Advent's building department, it's a separate subcontractor, the request was made on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for receipt of those. So we received those. So it's all been within a couple of weeks, plus we had the hurricane issue last week, and so I think there were issues as to the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and I asked them essentially what these matters were in relationship to, and was told that they already had those records and reviewed them. So I don't think there's any prejudice with the state based on our submission.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purposes of this hearing, I'd like the stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that the 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes.
Mhm.
And referring to 68 of the 81 that was
Yes,
entered
sir.
as one, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119, so that I may ask that out of the doctrine of completeness and fairness, that it be included. I'm just, at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119-page PDF and you make it word searchable, you just put in the magic word, and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide any
Okay.
information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may,
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. The court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident, as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter, so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough. But particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force,
Sorry,
the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats, prior events of violence committed under that instruction. Under the self-defense
Stay near the microphone, Mr.
Here's
Owen.
my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use them.
Okay.
The two I'm interested in using and opening is the standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence.
Put a lapel mic on him, for goodness sake.
Relied upon considering the verdict. You want to read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is not a possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge, it's opening statements. We should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may in fact read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements. I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions in limine, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from what
Give me a moment. That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions, 6 through 10, we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, that in many ways, we do it where we give them the law at the very end, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
Oh, I can L that. Jane, are you still in chat, darling? You still here? I just saw something on Twitter or X, and I've sent you a DM with the link to the song.
Opening statement is a picture of Sarah Boone that was taken by law enforcement on one of the
Speak up.
Here, which we believe is relevant, admissible.
Next photo.
This is the
Trying to get that sound to be a little bit better. It's just the defense attorney who will not stand anywhere near a microphone.
which is a picture of Sarah Boone on the back porch of the townhouse in question with her two dogs. Defense exhibit C, the blow up of the picture of inside the townhouse showing the sliding glass door as well as the staircase that leads to the master bedroom. And Defense exhibit D is a picture of the large screen TV with 6 or 7 holes in it from where George Torres hit the TV with a bat directly to Sarah Boone. Defense exhibit E is a blow up of injuries to Sarah Boone's left arm from George Torres. Defense exhibit F is a close-up of the wound to Sarah Boone's leg where George Torres stabbed her with a stapler. Defense exhibit G is a close-up of Sarah Boone's face that shows where George Torres poked her with a curtain rod. Defense exhibit H is a photograph close-up of Sarah Boone after she was kicked in the head by George Torres. Defense exhibit I is another close-up of Sarah Boone's face after she suffered injury at the hands of George Torres. All these, I believe, Judge, all these exhibits, except for the first one, A, were in Sarah Boone's phone. The state took custody of the phone. The state had the photographs. The state provided the defense in discovery of these photographs. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the home-size pages of the photographs and then using these as the argument today to show the jury during opening and then closing the injuries that Sarah Boone sustained at the hands of George Torres.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens,
Yes, Sir Judge, and I sent you some cases.
when did you send it, sir? I have not received it.
Yes, it's particularly Mr. Owens.
I think you were already on the bench, so we sent it to the clerk and Jake.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, I'll check.
Come on, get on with
Is it
it.
just these two cases? Been provided Alsager v. State, 326 Southern 3rd, 656, Florida Supreme Court, 2021. Low v. State, 259 Southern 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a
I believe you're arguing
state
over
wanted to
fucking
introduce
pictures.
a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alcaguer case,
Mm.
which is the
L.
2021 case,
L.
within its
Oh,
discretion to
oh.
use a mannequin in a demonstrative aid
Oh,
to
who
demonstrate
cares?
the trajectories.
Mhm.
As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence.
Told ya.
Signs different from normal. As we read into Jorge Torres, you may consider this fact in determining whether the actions of Sarah Boone are those of a reasonable person. Fact that determining whether Sarah Boone reasonably believed it was necessary for her to use non-lethal.
There you go.
Good faith belief that the exhibits will be introduced into evidence. There are demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Yep.
Thank you. Any
Told
response,
ya.
state?
Yes, sir.
Yes,
That
sir.
is the
Judge, the
the
standard
angle we'll take it.
is, it is your discretion, and you will only be reversed if you abuse your discretion in this.
That's fine, Udhef. I can contact you on Discord, but yeah, I can't. I don't have anything for Elizabeth or Teresia. I've got Kelly's, but yeah. And you do know how easy it is to create a generic Gmail. Just saying.
Regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements.
Mhm.
They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend.
I've actually got one for the defense rests, and I can't remember how to link it to my Google account. I think I've got 4 different email addresses linked to the one inbox, but I need to add one more. And for the life of me, I can't remember how I did it. It's on the list of shit to do.
The opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established, and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great
There you
bodily
go.
harm or death.
Overt act. Overt act. That is what they need. The defense needs to show to complete this battered spouse syndrome defense. Okay, so then basically it's like the trigger, the overt act. And that is what I'm saying could be what's contained in her testimony, because her testimony will become evidence. So an overt act could be, as I said, him saying to her whilst he's in the suitcase, just you wait until I get out. That is enough to trigger this extreme emotional response in her intoxicated state to elicit an overwhelming fear that she is in imminent danger, and therefore justifiable justifiable use of force, deadly force, can be established. Elizabeth, I've got yours. Teresia, no, not as yet.
And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly this is A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I, state is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that? prior
No, what I
ruling?
ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse. I said self-defense. Just these exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there is going to be evidence of an overt act. That she was facing imminent threat, and she reacted
Yep.
based on that.
I told you.
Understood. Your response to
That evidence of the overt act will come in under her testimony. Can't be rebutted, can't be disproved, can't be argued. That's why they're pushing so hard for this.
Exhibit B.
So look at B. Which one is B?
It's her on the back porch with the 2 dogs.
Judge, not only did he abuse, Jorge Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce, that they've listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, Jorge Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Mm-hmm. That's new.
Okay, thank you.
They're checking, Judge,
All right.
on whether they have.
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements.
Fair enough.
Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
Bring the jury.
They've been waiting for an hour and 20 minutes, Counselor.
Bring the jury.
We intend to play the 2-minute suitcase video to the jury in opening statement.
State.
Oh,
Again, I'm asking you to urge your discretion. They're going to hear it.
that's the state's case. He pointed out in the motions yesterday that the actual transcript of that video is their case. That's what they're basing their depraved mind and intent charges upon the case. That is their case. So if the defense is now asking to play that, why? Why? Because they can use it in their favor. and spin it to the battered spouse. Just listen and have that in the back of your head when they do the opening statements. Just assume that Sarah's going to testify that he threatened her whilst he was in that suitcase, and that then allows this battered spouse syndrome to take effect, and that it triggered her extreme emotional response in her intoxicated state, and they've established their cycle of abuse. That's why they wanted all of his medical records. Yeah? You watch.
In the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I don't want to be right, I promise.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. I'm not going to allow your photographs, not going to allow the state to do anything. You could orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
So the state, I think, plans to read the transcript out in their opening statement and not show the video, from my understanding yesterday in the motions hearing. And then they will introduce it as part of their case in chief through probably one of the first responders, no doubt. And once it's entered, then the defence can use it in cross-examination. But unfortunately, he was planning on using it in his opening statements to start the ball rolling, I bet you. Yep. I really, really hope I am wrong on this. You smarmy, cookie deprived. Can't remember, but who's learned how? I'm not sure. I think so. Yeah, I think so. He's been in it for 30 years, and yeah, I think so, Elizabeth. I'm not. Don't quote me though. I'm sure I could probably Google his resume. Okay, I got you, Teresia. I've got both of you.
Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense.
No, sir.
All right, let's stand and bring in our panel.
Bring the jury. Hallelujah. Amen. So I will send one of those links. Each stream has a different link. I will just forward to all the mods the link, and you can decide if, when, whatever you want to click on it, and it won't bring you up on the screen. It'll bring you up on the bottom of my screen, and only I can see you. And again, whether you want your camera visible or you just want an avatar there, fine. But you can access the private chat between mods
Y'all may be seated.
and me. And you can come up on stage should you choose to.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Can the parties approach for a moment?
Oh, really? That's the benefit of being a mod. You can come up and have private chats where no one else can see you. Except for the other mods that are on screen, like that are at the bottom.
All right, members of our jury, good morning. I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that
Now,
all jurors
I
have
got a
raised their
YouTube and
hands.
watched it.
Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did
Yep.
anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense?
You
All right,
can even
juror in
copy
seat
words.
number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment?
Okay, looks like this is going to be.
And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
Yep. We haven't even started opening statements and there's already a jury issue. I don't think it'll be an issue, but yeah. Hence the 8 alternates. I would have absolutely done the same thing. Could you imagine 3/4 of the way through this trial and you're down a juror and you can't continue? You just, like that. Like that.
All right, thank you both for your honesty. I appreciate that. Something we talked about earlier this week. That's the one thing that we required and asked of you, is just to be open and honest. And I appreciate both y'all's open and honesty.
Both y'all.
During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way, to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. Now, for conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, "Fuck you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." Yeah, That's what you do when you choke me. Sarah. 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 The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres is put into this suitcase left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, he took his little legs out. At some point she makes that statement. And tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out, gurgling. And the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, they'll co-parent. And that weekend included Friday, Saturday, Sunday. So it's that free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility.
So just those medical records that they agreed on this morning in the Richards, like all the pages they let in, they were dated the 23rd of January 2018. So it wasn't her BAC on the day of the incident, because that was the 24th of February 2020. So that, I think, might have been a previous DV episode that she's been admitted for, and they got those medical records in. That's what I'm assuming.
So February 23rd, 2020 was a Sunday. Now we've led into Monday. Mr. Boone had been trying actually to contact the defendant several times that morning. He just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that issue.
That shows.
So you You can see in the phone
Issue
record.
of the cycle.
Calls her, calls her, calls her. Then she finally calls her back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right. There's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check, please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside, though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. What you will not hear is sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office in autopsy. What the doctor found was what you would expect after being left in the suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, yeah, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion. Will help her explain confusions and bruises. She'll use words like hematomas. Will help her understand for you all that that means bleeding under the skin and blood, what you expect from a bruise. That's why they're running through. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body-worn camera. It's more of the same of what we heard on the 911 call. Hide and seek. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found at a suitcase by Mr. Torres, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were just literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full. So the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, the
Jesus.
equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can do
1 glass of wine and I'm asleep. That's what I drink.
Here's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price.
Alcohol
Those 2
abuse.
bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were.
Now ask yourself, why is she drinking that much? Why? Is it a coping strategy? Is the defense going to use that as a coping strategy to deal with her battered wife or battered spouse syndrome? So then it becomes a treatment of the syndrome. That's her way she deals with it to get through it. And then they can establish a pattern, a history, a cycle. So ultimately, they could almost turn the state's case against themselves, like against them. If what I believe is correct.
Were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus,
Got that brand
if you
of-
believe that the defendant and the decedent.
If we want to let's get effed up today, we use we have cask wine, and they're like I think a 3 liter, and on the inside it's got like it's not plastic, but it's like a silver bag with one of those chutes that opens up and fills. In Australia, it's called a goon bag. Don't ask me why, but yeah, it's very popular with teenagers because you can take it out of the cardboard box, and the actual contained, like the bag that the liquid is in, can be very easily concealed in hoodie pockets and all sorts. I learned that one the hard way from my youngest.
Would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine.
Mm-hmm.
So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money.
My issue, Teresa, is I'm all or nothing. So, yeah, I can't just stop at one. It's go hard or go home. That's why I don't drink, because I suffer from hangovers so bad.
So they're just doing puzzles and doing things to keep his mind off of it.
I've never had a
Doing art,
fireball,
playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase.
Let's hide in a glass square where no one can see me.
We both thought it was funny. I'm going to zip you up. Two little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made.
Yep.
No ill will between us last night. Last argument, maybe last week.
Yeah.
Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean the Orange County Sheriff's Office,
You have to make me one tan and welcome. Hello to
that's
Ballarat.
when they discovered the two
Punch it
videos
out.
that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there.
Yep. That's why his
There's a
testimony
discussion about
is
why
important.
she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres.
Oh.
She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events.
No, she wouldn't have had
At
it
this
a
point,
photo.
they
Right?
ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. So she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now.
Doesn't matter. It's a cycle.
Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words.
Doesn't matter that he didn't touch her that day, or vice versa.
What else is found on her
To
phone?
establish a pattern.
There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote unquote dad hit me in the face. The next text is, hide and seek, I shall.
She was probably pissed.
January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres. Referring to Mr. Torres. Getting rid of.
Sorry. That's not giving me premeditation.
And that's the case.
Mm-hmm.
That's what the evidence is going to show.
They have to prove intent,
We,
depraved mind.
the members of the jury in our journey through this case, are all going to come up to a door that
Third prong, I think, but
danger,
second degree.
out, stay away, by court order.
Reckless disregard.
And that door says the defendant's history with the victim. It is a door we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your house. Well, I participate during this trial. We're going to be invited in to the defendant's past relationship with the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony to be. And he made her curl up in a fetal position on her own porch for 4 hours. And she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who has serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these days are at bars, and there's nothing wrong with that. And it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes. Cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview, happened about a month before this. Bloody ear. A stab wound in the leg, which is perhaps described as sword fighting, playing around in medical evidence. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take the lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to
I wonder if her defense attorney will tell the girl that Sarah is going to testify. She is going to testify. She has to. If they go with battered spouse syndrome, she has to testify to lay the foundation to bring in all the DV evidence, all the all the reports, all the police reports, all the complaints, all the charges, because she had a battery and strangulation charge in 2019. He had 3 DV charges in 2018. So they need her to testify to lay the groundwork for this battered spouse syndrome. And she needs to show the cycle, the pattern of abuse, that there was a history of abuse, which is why they brought in all these medical records, his volatility, and yeah, it's my opinion that they're going to then attribute the alcoholism to her way of coping with this syndrome. The ex-husband will bolster that testimony because he's seen it. And if she gets up and testifies, that becomes evidence. And the only thing she has to say is, he threatened me that he would beat the crap out of me, or just wait until I get out of this suitcase, Sarah. That's enough for her to say. Then that triggered an extreme emotional response in the syndrome, and it was justified. She felt that she was in imminent threat, in danger of grievous bodily harm or death. That's all they need to get to. That's it. But the state has to prove to get to second degree the intent, that she had a depraved mind, and that it was done with a reckless disregard to human life. And I don't think they've proved that there. I don't think, if that's their case, I think we're screwed. I really think we're screwed. I hope I'm wrong. Wonder if her defense attorney will tell the jury that Sarah's going to testify. Yeah. But also, he is not allowed to question her. She has to testify on her own, like a story. He's not allowed to make any questions, because that can show bias. So she can pretty much say what she wants, because who's going to argue it? No one else was there. She can pretty much say whatever she wants and say that he said whatever she wanted him to say. And that is their, if you watch the motions hearing, they're arguing over that. What was the pivotal point, the trigger, basically. They have to prove that there was a pivotal act done to trigger this emotional response to set off this syndrome. And that'll be in her testimony. That's how they'll get it in.
And then apply whether or not these past instances have anything
Speak up.
with what happened on February 23rd. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance we may hear from some experts, psychologists and psychiatrists, about battered spouses.
Yep.
The state is not challenging in any way that battered spouse syndrome exists. Well recognized, the experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5. Diagnostic Statistical Manual, version 5.
So it's not in the DSM-5. I'm gonna Google the definition.
What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it needs these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. It gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between the experts. It's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have.
Can I share this? There you go. That's the Florida statute on the use or threatened use of force in the defense of a person. So a person is justified in using or threatening to use force, except deadly force, against another when and to the extent that the person reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force. A person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself, or to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in criminal activity and is in a place where he or she has a right to be. Because it was in her home, that adds another element to it. So the definition in Florida of manslaughter, it's manslaughter is defined as the unaliving of a human being by the act, procurement, or culpable negligence of another without lawful justification. And in cases in which such unaliving shall not be excusable homicide or murder, Although not defined by statute, manslaughter is considered voluntary when an unaliving happens in the heat of the moment without planning. Manslaughter is considered involuntary when it happens as a result of recklessness or negligence. If convicted of manslaughter under Florida law, a convicted person faces a second-degree felony, which results in jail time of up to 15 years, which is where the state got their 15-year deal from. But, yeah, then you add in the prosecutorial immunity and the home protection statute, where it applies to a person who is in a dwelling or residence in which they have a right to be. And then you stand your ground laws. And then you add the DV history. I'm a bit worried. Just a bit. Oh, what have I missed? I wonder. I know I've read that one. Do they have an Alex? I don't know. I doubt it. I doubt it. Should have been that. She didn't touch him. She didn't zip him up, and she's not required to save him from what he did. She'd already admitted in the police interview that, she'd done that, so she can't get out of that. So her first one was accidental. Then her second one, which still keeps her they can still get her on intent and depraved mind. The second one was self-defense, which again, they can still get her on intent and depraved mind, which gets her the second degree. But the use of this one, there's more to it. Yep. I'm just Googling the definition of it because I thought I had, but I hadn't.
In certain abusive relationships that are violent, to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence,
and financial. That's why they want to bring in the alimony. That's all part of DV.
And what it ties into at the end of the day, after we talked about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because
She shouldn't have said anything. She didn't have an attorney with her. Zip it. No self-snitching, dickhead. Yep. But this is my anxiety is going up. Because everything that's coming out of his mouth, I can spin. Having read that stuff, I can spin and turn it around in her favor under this syndrome, this defense. If he knows that.
the question would be, well, why wouldn't you leave? And Barrett's spouse syndrome, the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. And that explains why.
And part of that control is financial control. So that he was saying psychological, emotional, physical, financial abuse is part of DV, which is why they want the alimony in. It's got nothing to do with anything else. It is just another example of how she's being controlled and part of the cycle of abuse.
Well, now, returning to the facts of our case,
Motherfuckers.
what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get self-defense instruction. That's what it's used for. It's not used for
Audio is dropping in and out.
subjective beliefs that one holds. What you will also hear about these things is just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JVC pipes. This sucker's good to go. I'm good with it. You're not going to take that home inspector's report unless they lift the hood, kick the tires, do all the things that the box on here, the Carfax does. You want an expert to get reliable information. An expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story. Even if it's the patient, the client that is saying all these things have to be confirmed. You gotta find proper information. You gotta check reliability. Particularly in circumstances that we discussed. So, another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that spouse syndrome applies. Some people can go home and fight like cats and dogs. And that's just their day, and they get over it. They live their life and fight another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, it doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Hart will say it applies to this group. But we'll talk to her about what she relied upon to make that conclusion. We'll talk about some other things and take that journey together to get there. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, the state admits that you're going to return a guilty verdict for second-degree murder. The evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, could we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you. You may proceed, sir.
Ladies and gentlemen, good morning. Appreciate y'all being here. I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Beck. Now, this is going to be a several-day trial. Obviously, today, Tuesday, Wednesday, we're not sure, but I'm trying to make arrangements for witnesses to fly in, expert witnesses and whatnot, and we'll know more probably within the day, maybe Monday, so we can plan.
Speak up.
I know your focus is on this case because you took a note. There's no higher calling than to write on the wall. No higher calling than to write on the wall. And we're going to ask you again to write this wall. And find Sarah Boone not guilty. Because she was justified.
Justified.
To defend herself. That force was reasonable under the circumstances that existed between Sarah Boone
Thank you.
and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. And considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they lived. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of those larger bottles of the wine. And then, of course, there's a receipt and the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then they'll keep that bottle. Will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows this is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle. Well, she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they hold it back and forth. Well, she comes down the steps. She sees him getting in and settling in the suitcase. So she walks over there, and they see each other. They smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch. And at some point, he says, I can't breathe. Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to Get her to get him out, or what? But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get up. He has to sit and listen. It's a unique form of physical restraint.
Yep. Pretty
So
much.
she lets him have it. Says things she shouldn't say.
I've just been looking up those definitions and criteria for this defense, and I'll show you them during the break, but you're not going to like them.
You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch, turns her phone on, and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, the suitcase is flipped upside down. The zippers on the bottom. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes.
Uh-huh. What did he say to her in that time?
And what happened during that 11 minutes.
Yep.
Okay?
And she
That
will
is the key
testify to
to
that.
this case. Sarah Boone will take the stand.
Mm-hmm.
She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres.
Told you. Fucking
Which the
hell.
law acknowledges that
Exactly.
everyone
You can.
has a right
Can you not
to
see
invoke
what I was explaining?
self-defense.
Fuck me. If they can prove prosecutorial misconduct, and link it back to the home, and that she was she didn't have a duty to retreat, and she was in fear of imminent danger and threat in her own home where she's supposed to be. Apparently, her actions are justifiable, and the state has no other option but to drop charges. They cannot prosecute. I shit you not.
You're going to hear from the medical examiner. She is going to tell you about some bruising.
I think that's what's happened. She's agreed. She's admitted that she took to him with the bat, and in her head, she's like, "Oh crap, I've gone too far now. I'm gonna cop it." It all snowballs.
On Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to
I'll
explain
take
that
that
to
bit.
you. Why that happened. What were the circumstances surrounding that? Involving a bat.
You know what? I reckon I'll take the 95% that she will get a lesser included of manslaughter at the most. At the most. Because they only have to prove, the state has to prove beyond a reasonable doubt. They just have to put doubt. That's it. Not if you encompass the entire umbrella of this syndrome, and you add in the fact that it was done at home and that there was a trigger or an act or something that was said or done for her to perceive that she was in imminent danger, that's all they have to do. That's it. I shit you not. I've got it all. I've saved them all. We'll go through it in the break with all the definitions and we'll break it down. But if you read the definition of the prosecutorial misconduct law in Florida pertaining to duty to retreat and, justifiable defense, there's a chance. There's a
The
chance.
son comes and stays with them from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that George
I don't want to be right,
Torres
trust me.
used, and there's a video. where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate her.
They still have to base it upon the law, though. They've got to believe beyond a reasonable doubt that she met the criteria of second degree by proving intent, proving that she had a depraved mind, and that she acted with willful disregard to human life. That's what they have to prove to get to second degree.
Sarah loved you. You're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles.
That's right.
Her mental health struggles.
Yep. And no one can argue with her because there was no one else there.
Sarah had no intent to kill him. The prosecutor mentioned she wanted him to die.
Yeah, a text
Well, that's
message.
the truth. She loved
No,
him.
that's not strong enough for intent.
She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You've got to take that all into account to try to understand what happened.
Excuse me. All right. The definition under Florida statute for second degree murder. The prosecutor must show that the defendant has a depraved mind and a willful disregard for human life, that it involves intent to harm or kill, but is not premeditated. That's the definition of second degree in the Florida statute. First degree, you have to prove that it was a conscious decision, that it was planned or premeditated on top of that. But, yeah. That's what it... I've got the law up there. Oh, I've got it saved. We'll go through it later. But that's apparently what it comes down to. Yes, it was a stupid thing to do. Yes, it was an act that a reasonable person could see would lead to unaliving. But she was off her face. She wasn't reasonable. Mm-mm. That's going to go towards her ability to make conscious, informed decisions. Like her conscious state is altered. It's whilst what is it? Voluntary intoxication isn't a defence in itself. It can be brought in under this umbrella. Yes, that intent to harm is what will be her doubt. Yes, that's right. That's right. And if he can prove, or at least poke enough holes in the state's case to show that it was possibly justifiable and that she could possibly have perceived it to be the situation that she thought it would be that causes her harm, I can't see how they can get past voluntary manslaughter. I honestly can't.
And the circumstances surrounding this tumultuous relationship.
Have a listen to her voice in the tape though when they play it.
Now, you can find that Sarah's not perfect. And, she goes, as many of us do when we drink too much, you sleep in. She slept in.
She's got a history
11,
of passing
12,
out.
1, somewhere around there. She moseys downstairs looking for George.
Mosey. Mosey on
He was
down.
on the computer looking for a job. She looked outside. Maybe he's out smoking a cigarette. And she sees
Nope.
a suitcase.
Ow.
She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband. Really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And her son is at? Lucas.
It's a K. Lucas with a
The
K.
only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly.
Really?
She
She's got a
calls-
kid show?
Brian, what do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. He said, call 911. She calls 911 within a minute, 2. Detective Rodriguez arrives. They got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And they know what to do. They try to assess the situation. They start putting the tape out, and then they call for the homicide investigator.
I think that's who that
Which takes a little
husband
time.
spoke to as well.
So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. Right here, that. And then the next day,
Somehow I might be
they
responsible.
take Sarah's phone. Sarah gives them the phone, signs the consent. takes
Wasn't
the
me.
phone, take it to
I didn't
they
put
have
him in the
phone
suitcase.
extraction
Wasn't me.
people at the sheriff's department where they can take it and
Sorry.
take out all the data, all your phone calls, text messages, photographs, videos, all that. and they find these two videos. Sarah's not aware, she doesn't remember making the video.
If she did, she wouldn't have handed her phone over.
She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson, is her name. Chelsea Hobson. And they end up, Deputy Hobson was.
What I can't believe is that he has established this defense and this intricate defense in 45 days. If he goes where I think he could go, this man is brilliant. Brilliant.
Right. Or Detective Hobson. Right. They said, end up, hey, we're not going to bring your phone. I'm not feeling good. Pregnant. Can you come to the sheriff's department? Which Sarah Boone was to tell you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation.
Mm-hmm. They don't have to tell you the truth.
They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, we got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. But it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act.
So call a lawyer.
And it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you and read an instruction on evaluating a witness's credibility. And they'll talk about cooperative evidence, other evidence that's consistent with the testimony that Sarah Boone will give. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense, nonetheless.
That's only one element of this battered wife syndrome.
Now, as I said,
only one
the
component.
struggles that occurred, many of them involved the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there. So her attitude is not one of distress.
Mm-hmm. Why was she intoxicated? I wonder if he'll get to that. Why was she abusing alcohol?
We're here today, full packed courtroom.
Mm.
Judge Grant's here, but you're the most important people. Because you've got to decide this case honestly, fairly,
And according to the law.
And we talked about the two biggest principles from the Constitution that apply. In this case,
Proven guilty.
and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is
Would you believe that only one channel is streaming it? Only one.
innocent. And that belief stays with you throughout the entire trial.
Mm-hmm.
Because of that, she doesn't have to prove anything.
Nope, the burden
That's
is
why the
on
state went first
state.
in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation
Yep.
in this country. Proof beyond and to the exclusion of every
Every
reasonable
reasonable
doubt.
doubt.
You are going to have doubts about this case. But the most important thing is not to rush to judge it, to keep an open mind and understand there's two sides to this case.
No, there's three sides to
There's
every
their
story.
side,
His, hers, and the truth.
so you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in open or in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger.
And that perception was altered.
Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not.
Mhm.
After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment?
Fuck me. Fuck me. What is it? Please explain. Don't like it. Don't like it. All right, whilst they're on that, let me see if I can. The more I read, the more I cringed. All right, battered woman syndrome, the key elements of a diagnosis and treatment plan. Women who are victims of intimate partner violence have been identified by the mental health field for more than 30 years. It's understood that domestic violence is part of gender violence and that many more women than men are the victims of physical, sexual, and psychological abuse. Even when women strike back or engage in mutual violence, it is usually the woman who is most likely to be hurt both physically and emotionally. Women who strike back in self-defense are often arrested along with the batterer. Well, we have proof of that. She has been charged with battery of strangulation in 2019. It's further understood that gender violence is fostered by the socialization of men to be more powerful than women. In some men, this process creates the need to abuse power and to control women. While the term victim is not always considered politically correct, in fact, until battered women take back some control over their lives, they may not truly.
State, you may call your first witness.
State will call Juan Torres.
I'll keep going next. That's great. First responder, police, law enforcement, you reckon? 911 operator. Who do you reckon it'll be?
Mr. Torres, are you bringing a piece of warranties? Do you swear or promise the testimony you should give is shall be the truth, the whole truth, and nothing but the truth, so help you God?
Circuit Morty, you could be seated. And once seated,
Circuit
if you
Morty,
could
you could
state
be
and spell
seated.
your name for the record for us, please.
Juan Torres, Juan
The brother.
Torres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
Six or seven.
Jesus, didn't you have a
And
television?
how long has your family resided here in the Central Florida area?
20 plus years.
They must be
And
near you.
before residing,
Are they near you, Edith? Is Orange County near you? We need someone in that courtroom. We need a man on the ground. Man on the ground.
in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, say, on a weekly basis.
And how far away did you live from George?
Oh,
About
all right.
5-10 minutes. Very close.
Would you see him pretty often?
I would try not to go there too much.
Who was George living with at the time that he passed away?
Wait, Sarah.
And without getting into many details, what was your relationship like with Sarah?
We didn't really have a relationship.
I didn't
Would
like
it
her.
be fair to say you didn't get along with her?
Yes.
She's a nasty piece of work.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it. We just talked.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No,
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
no.
All right, sir, let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir.
And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No, because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell in her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes, sir.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point, your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can confirm.
You may, sir.
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
Christine, I sent you the link, darling, but just hang on till lunchtime. And then you can stay on from lunchtime all the way through if you like. And I've put the link in chat if anyone else would like to jump on at lunchtime and we can have a chitty chat. And what is it?
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DEVINJAMRO.
All
Thank you.
right, that's
You may
loud.
park, sir.
Sir,
Devin
who do you
who?
work for?
I work for public supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
So loud.
And at what location?
Currently the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
What was his last name? Oh, Gemro. Why am I even bothering to write it?
Your Honor, may I approach the witness which has been previously marked for identification as States D and been shown to defense?
D is in Delta?
D is in Delta.
Yes, you may.
F is in Foxtrot. U is in Unicorn. C is in Charlie. K is in Kilo.
Sir, I'm showing you it's been marked for identification as States D. Could you use these scissors and open this and look at the contents of this package to yourself?
So where is he from? Okay, so he's the wine cellar. Lordy be, we're going to get a lot of this. All the receipts on all the wine they bought. And you watch it turn around and bite them on the ass.
Sir, do you recognize those items?
I do, yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts
The Woodbridge.
evidence of transactions
Nice
at
job,
Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes,
And these fairly and accurately appear to be the receipts
Yep.
Mhm.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States D into evidence.
Permission to
objections?
publish?
No
Billy, do we
What
have
was
to look at them?
pre-marked as states D will be received into evidence without objection as states 1.
No? No permission to publish? They got scanned in. Do you hear that?
Your Honor, may I approach the witness who's been previously marked for identification as States J and shown to defense?
You may.
No, they might publish them. Why am I?
Sir, I'm showing you it's been marked for identification as States J. Can you take a look at that disc?
Yes,
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did, yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes,
And in the normal course of business, are the videos from those surveillance cameras kept?
yes,
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
yes,
And they fairly inaccurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
they do, yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States J into evidence.
Any objections?
Okay, so all the vulnerable?
No objection.
What was pre-marked?
One at 12:17, contents of this package to yourself.
Sure.
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep them subject to. Your Honor, may I approach the witness which has been previously marked for identification as States D and been shown to defense?
D's and Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as States D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do, yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes,
And these fairly inaccurately appear to be the receipts from your public store.
Yep.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States D into evidence.
Any objections?
No objection.
What was pre-marked as States D will be received into evidence without objection as States 1.
Your Honor, may I approach the witness who's been previously marked for identification as States J and shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as States J. Can you take a look at that disc?
Yes,
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did, yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes,
And in the normal course of business, are the videos from those surveillance cameras kept?
yes,
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
yes,
And they fairly inaccurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
they do, yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States J into evidence.
Any objections?
No objection.
What was pre-marked as States J will be received into evidence without objection as States 2.
And I have no further questions for this witness.
Any cross-examination? Can this witness be released?
Yes, yes.
Thank you, sir.
Thank you,
You're
sir. You're released.
Thank you.
Have a great day.
Have a great day.
State, you may
Hey,
call
you
your
may
next
call your
witness.
next witness.
We call Joe Williams.
Raise your right hand to the floor, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at the Orange County Sheriff's Office,
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes,
And those records are made at or near the time of each call, correct?
yes.
Your Honor, may I approach the witness what's been previously marked for identification as States L and been shown to defense?
You may.
Ma'am, I'm showing you what's been previously marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as states L, will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor. Yes.
Thank you, ma'am. Can the parties approach momentarily? State, you may call your next witness.
State will call Vincent Battaglia.
Raise your right hand and be sworn. Please be swear or affirm that the testimony you give shall be the truth, whole truth, and nothing but the truth, so help you God.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Him.
That's Brandon Motes?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and Jorge Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like it probably 4 to 5 months before that.
So 4 or 5 months before February
Of
of
2020.
2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of.
Sarah Boone.
Hang on.
So that's why.
Just instead of what somebody else told you?
Yeah. And it was never really anything clear. It was just like you could hear.
Months before February of
2020.
2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there.
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like and kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah. All the time, it was like a back and forth.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, then it was just like a loud rumbling noise. That literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like,
Hello?
it was like
Oh my God.
my patio, and that's like that was my bedroom back there, like on the grass back there.
On the first floor?
On the first floor, yeah.
I have no.
Can you all hear me now? Motherfuckers. Sorry, Christine. Sorry. Hang on. Oh shit, I don't even know how to. My arm must have brushed the goddamn volume control. Hang on, I've got to set this stream. I've only allowed one camera. Hang on, I'll add another camera slot. There we go. Sorry, poor Christine's been sitting there waiting patiently, and I couldn't talk to anyone. Sorry. Yeah, the last time I lost audio, I accidentally touched. There's a mute button on the side here. I didn't know about until I muted it, and no one could hear me. Yeah, but that one was a volume issue. My elbow must have hit it, and I'm sorry. Idiot. Okay, idiot. That's all I can say. All right. Can you hear me, Christine?
Hi.
Hello, hello, darling. Yes, I can hear you.
How are you?
Sally Sailor Mouse. I'm all right now. Yeah.
The audio sucks.
Ugh.
The audio from Law and Crime is.
Oh, this is terrible.
Yeah, I can
Yeah.
like nobody can hear anything.
Yeah, no, this was my microphone that wasn't working.
Oh.
Yeah.
And
No one could hear me talking.
Uh-huh.
Which is terrible.
Yeah. Well, I'm just saying from the law and tax crime stuff, I mean, the audio is really bad. Yeah,
I didn't think Law and Crime was streaming it. I looked at the site and it didn't have anything, but
Oh, they they did this morning. I mean, they did.
Oh,
And
okay.
right now they are lunch, so they're coming back at 2 o'clock.
All right.
So
I think we've got about 10 minutes before they break for lunch. So
Okay.
we'll run till then, and then we can all have a chat. How's that?
okay.
All righty.
Further
I'll
questions?
make this bigger
Any
now.
cross-examination?
Oh, my apologies, everyone. Sorry. Sorry for being such an idiot. What can I say?
Now, you said that you lived there next to Sarah Boone and George Torres for about a year.
Yes, sir.
Now I've got to open
Are
up all my
you
pages
aware
again.
that the police were called to their residence
Like,
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know from your experience with
Cool,
Sarah
that coming.
Boone and your experience with George Torres that they drank alcohol?
Yeah.
Hang on.
That's
I'll
not
withdraw
rocket
to that
science.
question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you.
Yes, sir, of course.
Oh, I better mute myself. I'm getting echo now.
Vincent, I think you had testified, you may have given a statement to law
Hit the wrong
enforcement,
one.
Yes, it was one of the detectives.
a recorded statement.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time. Yeah.
I believe you had said that
I'm going to object this to improper impeachment.
Approach.
Approach. Obviously, there is no standing objections. We're all doing sidebars. And I can't even L, I don't think. Can I? Oh, I can. Bloody L. Oh.
From work, probably around
I don't even know who's testifying.
1 or 2 o'clock or so.
in the morning,
No, in the afternoon. Because I went to work that morning at around 5 a.m.
and you said that you heard the normal yelling and arguing at about that time when you got home.
No, it
Good
was.
morning, Mary Adams. How are you? Yes. Yes, they were picked and finalised last night, and we are in, I think this is the fourth state witness of the day. I think it's fourth. Yeah. I just lost audio, so I've been playing with fiddling around with settings and stuff, so I don't even know who this guy is. I'm sorry. I'm sure someone in chat will help me.
Oh,
But welcome.
it's a roommate. It's roommate. His
Oh,
roommate.
a neighbour to George and.
Yeah.
Okay, cool. Thank you.
Well, yeah, it was around that time, but it was really
Thank you.
around like 10 o'clock, 10:30 is when like the arguing I could very hear clearly. It was like around 10:30 at night.
I think I need a coffee. What is it? 20 to 4. Yeah, I definitely need a coffee. So if this is going to go all day.
Thank you.
Any redirect?
Just Very briefly.
Yes, sir.
We've got another 4 hours of testimony, haven't we? At least.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
I'm gonna need sugar.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around.
Here's some sugar I prepared earlier. I'm gonna need it tonight, I think.
11:15, probably 30, 45 minutes after like the arguing, I could hear it started.
No other questions?
Oh.
Can this witness be released?
Yes, Sean.
Not subject to recall.
We would like him subject to recall. You guys know.
God.
Okay.
Your Honor, may we approach?
Yes.
They're keeping all their cards, aren't they? Just in case they need him to testify, to reiterate
Have a great day. Thank you.
the
The state would
Cycle of
call
violence.
Brandon Moats.
yeah, it's a
Bless
still
you.
a python. Mm-mm. Delicious. I'm gonna need it to be able to stay up all night. What time is it over there? 1:45?
12:42.
Thank you, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Moats, BRANDON MOATS.
Thank you. Mr.
I
Castro,
can't
you
even
may
get the
inquire.
CC right when he spells it.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Patak.
All right. This might be interesting. If she was a roommate of his when he was at school, pre-George, and she had alcohol issues then, that might be a I don't know what you call it. That might hinder their defense a little bit because then they can't use that. Oh, sorry, sweetheart. Here, can you get to your dinner? There you go. They can't use that as part of the cycle of the abuse. Does that make sense? Like, if she was drinking and had an alcohol problem prior to George, then they can't attribute it to the PTSD or the syndrome, is what I was getting at.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school.
Oh, no, it says
During the
maybe
time
on
of
both
this, yeah, I
them.
would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with Jorge Torres?
Well, that wasn't before then.
Honestly,
Know
I
all
avoided
that.
them as much as possible usually.
The apartment where you lived, tell us, how would you describe the walls that separated?
Who's in?
Yeah, I remember that my bedroom was like the front facing bedroom and our walls shared a wall with where their staircase was. So like the way the apartments were laid out, we had a 1-story apartment, they had a 2-story apartment. So they had a staircase running right next to the walls, next to like our bedrooms.
Would you
What,
ever
did a
have
suitcase
occasion
falling down the
to
stairs
hear,
wake you up?
arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin. So if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock.
You and me both, Mary Adams. But I bet you're closer than I am. What state are you in?
That evening, probably like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that
Next to
we
the
can paint
staircase.
the picture, where would that would it have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the 1 floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling, and it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling
Like
down
a
the stairs.
suitcase?
Did this affect the walls that were between your 2 apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally, like, it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, I never saw her after that happened.
No further questions.
Any cross-examination?
I have the feeling that the first few days of this trial are going to be pretty much like the Karen Reid trial. Was it snowing? How much snow?
Good afternoon, sir.
Were they fighting? How much fighting? How often?
Sir, you were asked by the state if
Clumsy, you wet.
you ever had any
Saturated.
interactions with Sarah Boone.
Wet
or
kitty on my
Jorge Torres.
desk.
Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
What are you doing?
Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
Okay. So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go home.
Now I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the boom, which was 10 something, initially it was around the 7 p.m. You heard arguing.
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home. So I would have gotten home around 5:30, and it would have been after because I came home, I made myself lunch and I took a shower, and then I heard all of their arguing. So it would have been about an hour and a half, 2 hours after I got home. So around 7 to 8 o'clock.
Okay. And during that time, when you say arguing, was it back and forth?
I honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth.
Let me ask you this: did you hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice? Yes. Okay. Were they both loud?
Yes.
If I can confirm, Judge.
Yes, sir, of course.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right, sir, you're released subject to recall. Thank you. Can the parties approach?
Why do they keep doing that? It must be raining outside. I have a a wet pussy on my desk.
This very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break.
Okay.
I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days.
How long did you say? 1 hour?
Yeah, 2 o'clock.
Oh, cool. 'Cause we're half an hour behind. So if I skip to the end, we've only got half an hour to kill. Woohoo! Sorry about that. That's half an hour of me interrupting and talking shit. Well. What do we think so far? What do we think so far?
Guilty.
Oh, for sure, but it's what they can prove. That's what counts, unfortunately.
Did you hear the opening statements?
Yeah, yep. Oop, how do I do this? There we go. Whoop. There we are. Look at that. That's probably a
So,
bit too big.
which one do you like better? Do you like the stay or the defense opening?
Defense.
Oh, okay.
Yeah. Yeah. I think the state have a weak case for what
We'll
they
see. We'll see.
for what they if they have done their research on
Mhm.
establishing what this defense of battered spouse syndrome is, they wouldn't be involved. They wouldn't have any of these witnesses on the stand because they're just adding to her evidence of a cycle and a history of abuse, which contributes to this battered syndrome.
Mhm.
Totally. So, yeah, I don't know what the procedure is over there or what happens, but what happens if the defence's turn next week comes on and they put her on the stand and the judge, who's obviously aware of the Florida laws and the statutes, and he recognizes that perhaps they have met this criteria, because if they can prove that she acted in a justifiable way, particularly because it was in her own home, then the prosecution has no other option, apparently, in Florida law than to drop the charges. Where did I put? All right, let me get these. I saved all the information that I got offline about what was involved with this battered wife syndrome and how it's what the criteria you need to meet and what the symptoms and stuff are. So let's have a look. There are apparently 8 criteria that define battered wife syndrome. First one is intrusive memories. Women with battered wife syndrome. Oh, I can share this, can't I? Can I share this? And then you can all see it. Share screen. Window. Put that one. Yes. Nope. Now we're back to that right? No. That right? No. Oh, look, that'll do. Can everyone see that? Make that bigger. You know? Can you read that? Is that clear or is it just my eyes?
You need to make it a little bigger. Yeah, you can. I can't. Okay.
That better?
Yeah. Well, I can.
Can you read that? Okay. It's in focus. It doesn't look in focus to me, but that's probably because it's 4 a.m. All right. Intrusive memories. Women with battered wife syndrome often re-experience past traumatic events in their mind, feeling as if they are happening over and over again. Now, they can prove that with the video, because she's saying to him, for all the things you've done to me, every time you've choked me, yeah? Intrusive memories. So you have the psychological effect of past events as well as the present event, which makes it even more scary and more frightening because pieces of the earlier abuse are in the person's mind at the same time. Second part of criteria is anxiety. Women with that battered wife syndrome have high levels of anxiety and hypervigilance when something doesn't seem right. This leads to the fight or flight response. This could mean being startled by noises and other triggers, crying often, and having problems with sleep. Avoidance. When a person can't physically get out of a situation, they might psychologically become distanced from what is ongoing by going into denial or minimizing what is happening to them and numbing their emotions. How do you numb your emotions? I wonder. Perhaps maybe with central nervous system depressant called alcohol. Cognitive changes. When you feel you have to protect yourself at all times, you can experience confusion and a lack of attention. All right. Add to that being totally shit-faced. That's going to alter your cognitive status as well. You might not be able to remember all the details of her abuse and have depression. Well, they've established that, haven't they? Oh, hang on. Battered women syndrome, psychological and behavioural pattern displayed by female victims of domestic violence. Explanations. Oh, hang on. I think I've missed a page. Have I? Oh, I said there was 8. No, I said there was 8. Mm-hmm. I've done that one. I don't know what I've done with it. I've done that one. I don't know. Oh, this is it here. Sorry. All right. Researchers have studied the long-term effects of brain injury on women who have been repeatedly beaten and strangled by their partner. They found, not surprisingly, that repeated brain injuries from abuse can have long-term effects on memory, learning, and cognition. Disruptions in other relationships. A key aspect of battered wife syndrome is when the attacker tries to cut off or control all relationships their partner has, so she can't turn to her friends or family for help. In one study of women who had experienced intimate partner violence, 62% said they were either forbidden or rarely had contact with friends or family. Health and body image problems. Not only is there physical damage from the beatings and abuse, but the extreme stress and anxiety can also lead to psychological symptoms such as headaches and gastrointestinal problems. Many battered women also don't eat well because their partner has so much control over them that they get a very distorted body image. Problems with sex. The person who's been a target of intimate partner violence may have long-term problems with intimacy even if they get out of the abusive relationship. Disassociation. Battered women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic experience. Perhaps maybe she uses alcohol as her mechanism of disassociation. That's where I'd be going if I was in her defense. The psychological and behavioral pattern displayed by female victims. Oh, let me give you the definition of domestic violence for a start. Social and legal concept that in the broadest sense refers to any abuse, including physical, emotion, sexual, or financial. That's why I said they're bringing in the alimony element because they are just going to say that it is another form of domestic violence and further impacts her financially from the ex-husband. Does that make sense? So she's being controlled on all fronts. The term is often used specifically to designate physical assaults upon women by their male partners, but though rarer, the victim may be a male abused by his female partner, and the term may also be used regarding abuse of both women and men by same-sex partners. Look, I don't doubt that she definitely gave as good as she got. You know what I mean? Like it was a volatile relationship. They were both at each other. I'm not condoning any of her behaviour by any way, shape, or means. I'm merely applying this defence strategy to her case and evidence in front of me. And I don't like it. I don't like it. All right. Explanations that have evolved since the late 70s include learned helplessness or a cycle of violence theory and a form of post-traumatic stress disorder. The term is a legal concept rather than a psychiatric diagnosis and lacks clearly defined criteria. This will be important because when we get the experts up, we'll know what they're talking about. It's been used to support legal arguments of self-defense, diminished responsibility, or insanity when a woman is accused of murdering or assaulting her batterer, committing a crime under his coercion, or provoking the behaviour the batterer is on trial for. Critics say the term creates a stereotyped image inadequate to describe individual experiences. Diminished responsibility, the legal doctrine that absolves an accused person of part of the liability for his criminal act if he suffers from such abnormality of mind as to substantially impair his responsibility in committing or being a party to an alleged violation. Oh, clumsy, get off me bloody, yeah, the cat's sitting on the mouse. Clumsy, friggin' hell. Bloody animals. Now, what did you do? Lord. Where was I? The doctrine of diminished responsibility provides a mitigating defence in cases in which the mental disease or defect is not of such magnitude as to exclude criminal responsibility altogether. It's most frequently asserted in connection with murder cases requiring proof of a particular mental state on the part of the accused. If a judge or jury concludes that the accused is incapable of premeditation, yet has the capacity to appreciate the wrongfulness of the conduct or to conform their behaviour to the requirements of the law, the court can bring a less serious penalty to bear. Generally, the defendant who successfully establishes this abnormal mental condition is found guilty of manslaughter instead of murder. Few jurisdictions subscribe to the doctrine of diminished responsibility, although a long part of Scotland, because of the unique circumstances that people can find themselves in, battered wife syndrome may not look the same in everyone who lives with it. That being said, there are generally thought to be 4 stages of battered woman syndrome. 1, denial. The person is unable to accept that they're being abused, or they justify it as being just that once. 2, guilt. The person believes they caused the abuse. 3, enlightenment. In this phase, the person realizes that they didn't deserve the abuse and acknowledges that their partner has an abusive personality. And 4, the responsibility. The person accepts that only the abuser holds responsibility for the abuse. In many cases, this is when they'll explore their options for leaving the relationship. All right, well, I don't think, oh my God, I don't think they've got that far. Hang on a second. I don't know if you can you see that? Hang on.
It's blank.
Yeah, hang on. Add it to screen. Clumsy. Yeah, this is the cat is on my mouse pad on my desk right there. That's the cat. Say hello. Walking everywhere on top of everything. Little weirdo. All right. Let's go back. So, yeah, I don't like it. I don't like where this is going at all. At all. Yeah.
Jersey might be small.
What's that? Was that me?
No, me. Sorry.
Oh,
I
that's
was
all right.
doing something. I'm sorry.
That's okay. I've had audio issues. I didn't know where it was coming from. All right, who should we stalk? Does anyone want to come up and have a chat? Come up on screen and have a debate. Have a discussion on battered wife syndrome. Oh, has anyone actually got the list of witnesses by any chance? Do you know
Oh,
how many?
someone sent me one, but I don't know how to. Wait a minute. Yeah, someone sent it to me. I can forward it to you somehow.
Did they send it via email or?
It was by um 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 one of those PFD ones.
Yeah, but on what? Was it like on Messenger or email or?
Or it was on um on Excel spreadsheet.
Yeah, but how did they send it to you?
It was on Discord. I'm sorry, it was on Discord.
Oh, well, I've got a Discord account. If you want to send it, I'll give you the link right now.
Okay, let me go find it. Hold on.
Copy.
Hold on. Where is it?
Paste. There you go. Why have I got this help button right? Why is it there?
Why is it not going? Hold on. Just. Notes. I'm trying to do this. Where will this go? Just gonna make it. Wait. Okay. Just go to
I don't know what I've done, but I've touched something. Hmm.
Did you get something? Get it yet?
I just sent it, did you?
Yeah,
Hang
just
on.
yeah.
I've only
Okay.
got Discord on my phone. Hang on. Did you send it via a message or to my?
I sent
Oh,
it from Discord to you.
yep,
Yeah.
yep. Potential witnesses. Woohoo!
Yeah. Someone sent it to me.
Oh, actually, I think I got the list of
Oh, you did? Okay.
potential, but this was last week. Is that right?
I have no idea. They just sent it me last night. Whoever this was.
Okay. Hopefully, it's the updated one.
I think so. I think that was the updated one.
Why won't you open? Now my phone is frozen. Oh Lord.
And I don't know how to.
Technology and I are not working together. Open. Open it. All right, back here. I'll open Drive on the computer stuff. Yeah. That's why we have Google Drive, isn't it? So we can access anything anywhere. Did it save though? Hello, Moo. Hello. Hang on. I might as well put. You may as well watch the cats whilst I'm searching for this. All right. This is literally curled up on my mouse pad. And there's the other one. Having some. Oh, you're wet too. Ah! You can't see them when my camera just misses them. They walk underneath it, so you often just see a tail going past. But yeah. Oh yes, I've got them. Open. Google Sheets. Okay. So
You got
the
it, right?
state, yep.
Okay. Making sure.
Thank you.
Mhm.
Let me see. He's got his head on my hand while I'm trying to work the mouse. It's very cute, Clumsy, but it's not conducive. I'm sorry. Let me share. There we go. Add to screen. Okay, so this is the list of potential witnesses. Can you read that? I'll make it a little bit bigger. There we go. This is the state. So, who have we had so far? We've had uh, Juan Torres, this one. What if I make that? If I fill that with, there we go. We've had him. Who else have we had?
The other roommate, but I don't know his name. Don't know his name.
That one. We've had him. We've had, it was Brandon that was on too, wasn't it?
Yeah.
I think he was. And that last guy, was that Abraham, the neighbour and friend?
Yes, I'm pretty sure. I think so.
Jody, Florida would have only been required to drop the charges if Sarah had successfully won. Yes, it's got to be done before trial, which is why I reckon they were scrambling with all of these motions just prior to the trial, because I think they were trying to find they needed to find that pivotal point, that that pivotal act, as the judge was saying, that triggered the response to be able to claim the battered wife syndrome. But they couldn't find anything, and they weren't allowed to bring any extra evidence in. So the only way they can bring it in is via her testimony. So they have to wait now, because the only way that they can drop the charges in a stand your ground hearing, you're absolutely 100% right, is in a pre-trial motion. They can't do it. But if they can establish that the behaviour was like justifiable, so to speak, under their definition, I don't know what the rules are under Florida, like what the repercussions as far as prosecution is concerned. Oh, the 911 operator. Thank you.
Yeah, that's right.
Where is she? What was her name? Had store clerk and the 911 operator, which was oops. Who was that? Are they even on there? Also, I'm not sure exactly what the burden of proof for a stand your ground hearing, but I know it's different than just reasonable doubt. I think it has to be. I have that somewhere. I have the statute on the stand your ground. Where the hell did I put it? Because I closed everything down before while I was trying to fix the audio. It's on Google Drive. Felix, come here. Come on. Come on, baby. Mummy's here. Sarah Boone. Come on, I'm here. All right, it'll be one of these. This is the statute for home protection use or threatened use of deadly force, presumption of fear or death or great bodily harm. That's not the stand your ground one. That's the one. Prosecutorial immunity. Okay, the procedures for asserting prosecutorial immunity under the initial stand your ground provisions outlined in Peterson v. State 983 SO. That's Oh. Mm. Peterson definitively establishes that Section 776032 was created by the Florida legislature to create a true immunity and not merely an affirmative defense. 776032. Okay, this is 776013, and I've got the other statute there somewhere. 776012. That'll be right. All right, let me look up Florida statute. 776032. What did I say? Seven. Shit, I can't even remember it now. 776032. All right. Florida statute, stand your ground. I suppose I should share this tab instead. How do I make that bigger? Stand your ground law in Florida. Okay. Oh, look, they've got a 4-minute listen. Hello, Howard. National Rifle Association, I suppose. Mhm. Hmm. Yeah. See that that stand your ground is it's like the broad spectrum stand your ground definition, but it's the stand your ground reasoning and meaning behind that applied to the being able to protect yourself in your own home and not having a duty to retreat. The application of that law within that window. Does that make sense? What does that say? A stand your ground law, sometimes called a line in the sand or no duty to retreat law, provides that people may use deadly force when they reasonably believe it to be necessary to defend themselves against certain violent crimes. Under such a law, people have no duty to retreat before using deadly force in self-defense, so long as they are in a place where they are lawfully present. That's the difference. The difference is that she was at home. And so that apply. Do you know what I mean? That allows it to apply to her. The alternative to stand your ground is duty to retreat. In jurisdictions that implement a duty to retreat, even a person who is unlawfully attacked may not use deadly force if it is possible to instead avoid the danger with complete safety by retreating. Jurisdictions. Defense, use of threat or force. A person is not guilty of an offence if A, they believe on reasonable grounds that force is being used against them under another person or that a threat of force is being made. No, that's probably not applicable, is it? Determining whether the act committed is reasonable in the circumstances, the court shall consider the relevant circumstances of the person, the other parties, and the act, including but not limited to the following factors: the nature of the force or threat, the extent to which the use of force was imminent, and whether there were other means available to respond to the potential use of force. Now, that's all force. I want. The size, age, gender, and physical capabilities of the parties to the incident, the nature, duration, and history of any relationship between the parties to the incident, including any prior use of threat or force, and the nature of that force or threat. Any history of interaction or communication between the parties to the incident, the nature and proportionality of the person's response. What does proportionality mean? General principle in law which covers several separate concepts. The concept as a criteria of fairness and justice in statutory interpretation processes. Within criminal law, the concept is used to convey the idea that the punishment of an offender should fit the crime. Under international humanitarian law governing the legal use of force in an armed conflict, no. Under the, no, I don't want that. That's European, don't want that. United States. Okay. Proposed the proportionality doctrine in these three cases during the 80s. To clarify this key principle of proportionality, with the cruel and unusual punishment clause The fundamental principle behind proportionality is that the punishment should fit the crime. Let's have a look at that. What is cruel and unusual punishment? Is a phrase in common law describing punishment that is considered acceptable due to the suffering, pain, or humiliation it inflicts on the person subjected to the sanction. The precise definition varies by jurisdiction, but typically includes punishments that are arbitrary. I think I've gone down a rabbit hole here, haven't I? Let me go back. United States. All right, United States. Let's go to Florida. I don't know, it's that bit down here. That bit right there. Stand your ground by judicial decision or jury instruction. Stand your ground by statute. Okay, let's go by statute. How do I? You go there. And there. I have no idea where I am going or what I'm doing, but meh. What else are you going to do when there's no court on? I don't know what I'm clicking on. Go back to that. All right. Stand your ground law, definitions, examples, cases, processes. That US? You will see, but you can't even see my screen, can you? No. My bad. Okay. Stand your ground law is a law that allows citizens to protect themselves if they feel their lives are in danger, regardless of whether they could have safely exited the situation. For example, stand your ground law states that no one should feel forced to leave a premises they have every right to be in. Definition, a law that allows a citizen, yeah, we've done that. The meaning of stand your ground law is rooted in home defence. For this reason, another name for it is the castle doctrine. That's right. That's right. I was looking at that. Okay. This is another thing that impacts. What the friggin' hell are all these ads? Bugger off. Definition of castle doctrine. God. Piss off. Go away. Can't read under it. Oh, why can't I read under it?
What was that noise?
No idea. The term castle doctrine refers to the legal right of a person to defend himself against an intruder in his home or other property, even should the use of deadly force be required. Under this legal theory, the homeowner is not required to retreat but may stand his ground to defend himself, his home, or his property. If I could read the definition, I would, but I can't seem to get rid of that goddamn ad. I can copy that, paste it into a notepad. See if that works. I got half of it. When an intruder comes into a person's property or into his home or business for the purpose of committing a felony or to cause bodily, this doesn't really. Castle doctrine holds that a person in his home, on his property, or in his place of business may use deadly force to protect himself from violent attack. There are 3 types of self-defense law that exist in various states, each defining whether and under what circumstances deadly force may be used. These include 1, stand your ground, 2, castle doctrine, and 3, duty to retreat. So, the self-defense argument at trial. Let's have a look what that says. More ads. There's like 20 of them on the goddamn page. Jury trial? Jury trial is held before panel 6 to 12. Yeah. The acquittal and civil liability. I don't want that. The acquittal in criminal court did not represent. Oh, so O.J. Simpson got the acquittal under this. Lack of incontrovertible evidence of his guilt. The families were able to prove to the civil court by the preponderance of evidence that it was more likely than not that he was liable for their deaths. The jury awarded the families 8.5. Acquittal, a judgment that a person is not guilty of the crime which they've been charged. Preponderance of the evidence, the belief by a jury or judge that evidence presented by one party in a civil lawsuit. Yeah, I think I've gone down the rabbit hole. I need to go back. You got me down this rabbit hole.
I got to get some.
Yeah. In other words, shut up, Jody. We've only got, well, you were the only one left watching it, Hef, so I might have to go and have a twinkle, I think. Can you remember who was what in here? I might have to go back and see who we had. Okay, he was the one, yep, okay. Then we had, let's see, Devon, yeah, got him. Then we had, that's the 911 operator, wasn't it? I never watched it. I heard it. Joan Williams. I never really. I wasn't really into trials and stuff then because I don't know why, but that was a while ago. She's not on there. Joan Williams. Perhaps I'll add her. Joan Williams. So let's fill her in. Did you hear my song that I made up, Christine?
Yeah. Yeah, I did.
Did you have a laugh?
Yeah. No, it was cute. It was good. It was good.
Oh, look, it's something to lighten the mood, isn't it?
Mhm.
And who was he? Landon Mosey. I got him, and that was it. Okay, we're up to date. Cool. So, when did they go to lunch? What time did they say they'd be back?
2 o'clock. And it's 1:47 in Jersey time.
Sweet.
Jersey.
Teresa, you remember when I was doing the hurricane trial, how I actually got the entire time completely ballsed up and was early?
Mm-hmm.
I was 12 hours early.
Mm-hmm.
My mum rang me tonight. This is how little I get out away from YouTube, the YouTube world, right? Doing research and background stuff and graphics and designing and all this sorts of shit. She rings me up at, I think it was 8 o'clock tonight. And she said to me, "Oh, she lives in Queensland and I'm in Melbourne." She said, "What are you doing?" I said, "I'm just about to organise something for dinner because I've got a trial on tonight." And she said to me, "Well, don't forget the time difference is an hour difference now." I'm like, "What are you talking about?" She goes, "Daylight savings." I said, "It's not time for daylight savings." She goes, "Jody, daylight savings started last weekend." Yep. Apparently the clocks went backwards an hour last week. That's what stuffed me up. So now, does that mean I'm totally confused now. So it was 14 hours ahead on Eastern Standard Time. So does that mean I'm 13 hours ahead now? But I'm 12 hours ahead of Florida time. Is that right? Oh, so you get daylight savings time as well. Oh, that's just going to confuse me even more. What are you doing to me? What are you doing? Oh my God. International time zones. Okay. Chicago. Well, that doesn't really help me. 2:10. What does that mean? I have no idea. No, don't know. I'm assuming that I'm 13 hours now. I'll say that. Yours go back. Did mine go forward or back? I'm gonna have to Google this now. No. Okay. Time zone difference between Florida and Melbourne. Florida time to Melbourne time conversion. World clock. All time clock. I need to have a world clock on my taskbar. Melbourne time to Miami. Time difference between Orlando, Florida and Melbourne is 14 hours behind. Yeah. But is that daylight savings time? Time zone converter. Okay. Add location. Melbourne. To go back. Florida. Okay. Miami, Florida. That's okay. So if it's 4:52 a.m. on the 19th, so we're 15 hours ahead. So is it? You're in Eastern Standard Time, aren't you, Christine?
Yeah, Eastern
So-
time. Yeah, yeah.
So, but in Florida, it should be 1:52
Yeah. Mhm.
p.m.
Yeah.
But didn't they say they're coming back at 1?
No, they're coming back at 2 Eastern.
Oh,
2
okay.
o'clock. Florida.
All right. So,
And that's what they just said. They're coming back at 2 Eastern time.
okay. So, if I put, say Connecticut, that's Eastern Standard Time, isn't it? Connecticut. I don't know how to spell it. Connecticut. No, can't spell it. What's on the East Coast? Oh, Boston. There we go. Boston, Massachusetts. Well, how come? So, hang on. Eastern Standard Time and Florida time are supposed to be an hour difference, aren't they?
I have no idea.
I'm sure they are. Florida is always an hour less than we put Eastern Standard Time. No, it's saying the same time. Well, NFI. Absolutely no freaking idea. None. Yeah. Can I put that on my taskbar? No, doesn't look like it. What if I pin it? There we go.
I still
Oh.
need to call Ty, but I
Oh,
haven't.
yes.
I haven't called Ty yet. I will
You
eventually.
calling him on Monday?
No, no. Actually, I've just been busy going to doctor's appointments, so I haven't got a chance to talk to him yet. I know. They kind of had the hearing on the 15th
Of
of
November,
October,
yep.
but I don't know what happened. I'll probably call him over the weekend.
Okay. Well, I went and onto the Monroe County Sheriff's office or the clerk to get the documents. And there's only a couple of documents in there. There's his motion to continue, I think.
Okay.
I saved them.
Mm-hmm. Yeah, they were. Yeah, Yeah, yeah.
There wasn't a lot in there. It didn't tell me much anyway. So and the minutes said absolutely jack. There we go. There's the so the
Yeah.
court minutes were nothing. It was a motion for the continuance. It was a motion for disclosure of impeachment material, and there was a list of documents that he'd had access to when he was at home on his laptop, but doesn't have them now because he can't access his laptop. So there was a list
Mm-hmm.
of documents that he was requesting from Discovery that were missing there. But that's it. That's all they had.
Yeah, I know. Same thing. I looked at
Yeah.
the documents too,
It
but
tells you nothing. So I have no idea what happened at the hearing. I don't know if he's spoken to Steve, but I've apparently got or he wants to have a meeting tomorrow, Saturday. Sorry, my Sunday. His Saturday. But
who?
I haven't.
Steve?
Yeah.
Who? You and Steve and Ty? Or
No.
oh,
Just me and Steve. Because we're working on a podcast, so
uh
I
huh.
need to. He's so hard to get hold of. I need to nail him down.
Yeah.
um, so we need to finalise what the day and time each week it will be, and then I can start organising and promoting and when we're going to
Mhm.
launch it. So
Yeah.
yeah, he said he's free Saturday, but he's got to get back to me with the time. He's got a lot going on.
Oh no, I
Poor
know.
bugger. Poor bugger. So much going on. His
I
wife's just
wish
gone back
we.
to work, and he's the stay-at-home dad now.
Yeah.
And there's a lot of family health issues as well, and
Mhm.
yeah, so
I think I think Ty has lots of issues too, like health issues too. I heard.
oh yeah, I don't think he's getting enough vitamins and sunlight, basically.
I have no idea.
Yeah,
I'm worried about him. So
yeah.
like he just I wrote him a letter like a couple weeks ago. Like I haven't heard from him. So he just probably I think he's probably working on the probably he's working on those motions anyway.
Yeah.
So like he can get the like try to set the hearing up for
Do you
the
know?
there's
Do you know? You know how the Third Circuit Court of Appeals has accepted his letter? Do you know when that hearing is?
no, not yet. I've been looking, but there is no date yet for it yet. It's still active, but there's no date on it yet.
Okay.
There's no date. I mean, I've been going on the website too for his thing, and so far
It won't.
it
It
just
won't be on the Monroe. I don't think it'll be on the Monroe um, County Clerks. It'll be on
no.
the Federal Circuit Court of wherever he sent it to.
Yeah, he's very Oh. Can I call you? Can I let you go? My mom just came in, so can
Yeah,
I
no
call
worries.
you back in
Yep,
chat a couple minutes? I'll come right back. My
no
mom
worries.
just coming, so I
Yep,
just want to talk to
okay,
her for a couple seconds. I'll
no
talk to you
worries.
soon.
Don't rush. Take your time.
Okay.
Bye.
Okay. Bye, hon.
And that leaves me. Suffer in your jocks. You've got to put up with me at 5 o'clock in the morning. See, I need to go and wash my hands. I've been scratching a kitty cat, and my fingers feel dirty. Dirty. All right, let me get set up, ready to. Oh Lord, won't you buy me a big diamond ring? My friends all drive horses and I cannot sing. Maybe we need a tune. Do we need another tune? Yes. Let's have a tune, shall we? I need a wee, so you can listen to my tune. That's how I roll. And ready? Have you got your your cowboy boots on? Some boot scooting music. I'll be back.
So my name is Sarah Boone, and I'm on file for my life. And my defense in this darn trial is that I'm just a battered wife. My boyfriend George and I would drink and end up in a fight, till a game of hide and seek caused massive changes overnight. You see, we had been drinking wine, and I was probably off my face. And my boyfriend thought it cool to put himself in a suitcase. When I zipped him up inside, he started calling out my name. So I recorded what he said, cause I thought he was so lame. I was so drunk that I passed out, woke up with a thumping head. And when I opened up the suitcase, I found my boyfriend who was dead. Now they charged me with his murder, and I've been locked up in this jail. And my fate may be decided from my recordings of his wail. And in my statement I would say that the game of hide and seek is what we both wanted to play. And then I got some useless lawyers that were really effing dense, and they refused to change my claim to make it out of self-defense. So now I'm on my ninth attorney, and 5 long years has been a while, writing letters to the judge while I've been waiting for my trial. So when James Owen saw my ad and chose to help me save my life, he then put forward a new motion to claim defense for battered wife. So let's see who has the power. But I might stink during the trial if I don't get a doggone shower. I want my chippies and Pop-Tarts and a box of cookies too, and maybe add to that some water and some peppermint to chew. So my name is Sarah Boone, and I'm on file for my life. And my defense in this darn trial is that I'm just a battered wife. My boyfriend George and I would drink and end up in a fight, till a game of hide and seek caused massive changes overnight. You see, we had been drinking wine, and I was probably off my face. And my boyfriend thought it cool to put himself in a suitcase. When I zipped him up inside, he started calling out my name. So I recorded what he said, cause I thought he was so lame. I was so drunk that I passed out, woke up with a thumping head. And when I opened up the suitcase, I found my boyfriend who was dead. Now they charged me with his murder, and I've been locked up in this jail. And my fate may be decided from my recordings of his wail. And in my statement I would say that the game of hide and seek is what we both wanted to play. And then I got some useless lawyers that were really effing dense, and they refused to change my claim to make it out of self-defense. So now I'm on my ninth attorney, and 5 long years has been a while, writing letters to the judge while I've been waiting for my trial. So when James Owen saw my ad and chose to help me save my life, he then put forward a new motion to claim defense for battered wife. let's see who has the power. But I might stink during the trial if I don't get a doggone shower. I want my chippies and Pop-Tarts and a box of cookies too, and maybe add to that some water and some peppermint to chew. So my name is Sarah Boone, and I'm on file for my life. And my defense in this darn trial is that I'm just a battered wife. My boyfriend George and I would drink and end up in a fight, till a game of hide and seek caused massive changes overnight. You see, we had been drinking wine, and I was probably off my face. And my boyfriend thought it cool to put himself in a suitcase. When I zipped him up inside, he started calling out my name. So I recorded what he said, cause I thought he was so lame. I was so drunk that I passed out, woke up with a thumping head. And when I opened up the suitcase, I found my boyfriend who was
Ah, that's better. Oh, my eyeballs aren't floating. And I have coffee. And I have fruit and yogurt. I'm set. Setting that was it, I think. Come on, peoples, come back. You're 9 minutes late. Did you hear that? Did you hear that, mister? They're late. They are. You want to say hello? Come on then. Come on. Let's say hello. Let's say hello. 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 That's look at all that fur. Eh? You say hello to everybody? Hmm? 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 They're nice? I slept really, really late today in preparation, which I've tried to do all week, but I've definitely jacked up on the caffeine and the energy drinks. I've just got myself another coffee and a Gatorade and yeah, some fruit, some strawberries, mangoes, fresh that I cut up, and yogurt for my snack. So I will sleep until I'll be basically doing like night duty. from here on in. I think. I'll see how long I last. I might have to at some point start doing like the recaps. So watch the trial during the day, and then that next morning, like your next morning, present it and skip all these breaks and stuff, because it's the breaks that kill me. You know, you pretty much lose nearly 2 hours sitting here doing nothing, waiting between sidebars and lunch and morning and afternoon tea. Yeah, I don't know if I can sustain a midnight till 8 a.m. shift for 3 weeks, because that's what they've allowed for this trial, 3 weeks. Don't ask me why. I didn't think it was that detailed, but as I said, I think we're going to have something reflective of Karen Reid, where they baffle you with bullshit. With every neighbour and every possible person they've ever bumped into that's heard them argue will be a witness. So, yeah. Oh, look. You see my side view. Not very pleasant, is it? Sorry about that. Yes, I basically chopped up a fresh mango and a punnet of strawberries, and I've got a tub of yogurt that I mix through it, and that's generally what I have at 1, 2 o'clock in the morning midstream. And then when I'm finished my stream, I have, especially if it's around the 4 o'clock, 5 o'clock mark, I'll feed the cats early. I have a couple of bits of toast and go to bed with a cup of tea. Yes, and then they don't wake me and I can sleep uninterrupted, because if I don't feed them before I go to bed, about 7 o'clock, they will just be all over me. The best fruit that I have ever had has been either in Thailand or Bali. They are just delicious. You cannot go past. Oh, Queensland as well. Sorry, mangoes in Queensland. I put a blanket here for you to lay on, and you're on my mouse pad. Come here. Come on. Come here. Come and lay on this. Come on. No, you'd rather my mouse pad. Closer to your hand, Mum. Oh, and I'm recording you licking your butthole. That's lovely. Charming. You're on the internet and you're cleaning your butthole. Clumsy. Stop it. No, you're not doing that on a live stream. I will only allow so much. I'm fairly liberal, but that's no. Look at me, Mum. Now go and brush your teeth. Dag. Ew. No pun intended there. Well, it's you and me, Tracy. There's only one person that's watching, so suffer. I don't know whether it's worth me live streaming the first half of the trial and then cutting off at the 4 a.m. and then starting up again the following day with the second half of day 1 and then the first half of the next day. You know what I mean? So I'm only a half day behind, but it's hard because, all the big guys can run 8 hours during the day, no worries. And that puts me at a disadvantage again. So I don't know what to do. Don't know what to do. I had to follow this one because if I didn't, just you just couldn't. It was like not following Amber Heard and Johnny Depp, like or Karen Reid. You had to do it. But after this one, I think I will go back to some trials that are a bit older, that aren't live. And if I'm doing a live, I'll do it as a recap and start it a day behind. I'm just going to have to. I don't know what else to do. My son had a small dog once, and every time someone would come, it would just where it drags its butt across the ground. Did you want to? Yeah. So it's what? They're 27 minutes late now, and I like watching them. Yes, so do I. So do I. Yep, I've got like 9 trials saved, ready to go. Like, I haven't researched them, but I've saved all of their like every day of the trial. I've got them in playlists ready to go, including this toddler in the trash one. So I can run that next if we want to, but then see most people have seen it, or have they? Because it's being run at the same time as this. So I don't know. That's why I decided to run the burned husband one as a sleep stream, because, well, I may as well. I just run it without the commentary. It adds extra hours to my watch time hours, and it provides 8 extra. It's an extra playlist of trials that people can watch, and it's there forever. It's not like it's going to go away. Yeah, you've been waiting on. Okay, all right. I haven't watched any of it either, but I've saved it. They're on day 5, I think, at the moment. I don't know how long it's supposed to go to, but yes, we can definitely do that next. No worries. That's easy. I'm hanging to get into. I might actually do the Lindy Chamberlain one more like a documentary, like a presentation type of thing, because I'm not going to have like days of trial to go with. I'll have patches of it, but I think, I might do it more as a presentation as such, like almost a podcasty type thing, and go over the facts of that, because I was only young when that happened, and it's one of the biggest trials in Australia. So, but I'm looking forward to if Steve pulls his finger out, starting up this podcast, because that'll be interesting. Be really interesting. Not so much research, more opinions, more interaction, more question and answers, more more everything. So, and he knows so much more on the law and procedures and protocols that, yeah, he can provide so much more information. So what we were planning to do was, say there was a controversial trial, so like Sarah Boone, we could discuss all of the aspects of the 3 different defences that she's put forward and the implications, and what that would mean if this happened, and he can go through and explain why they've done this, and all that sort of stuff, whereas I can go through all the medical examiner stuff and break that down more. And so we bring different experiences to the table and have different obviously opinions and perspectives. But I was planning on having a guest speaker each time as well, an extra person. So yeah, it should be good. Looking forward to it. Once it keeps going. Yeah, I think it does. I think it does. Yeah, pretty pleased with how it's all turned out with the graphics, and as I wrote that theme song as well, the intro and the outro, did all the logo designs and so Felix, come on, Felix. Oh, it's moving. Come on. Oh God, it's good. What are you scratching for? You've had your drops. What are you scratching for? I don't hardly go in. Yes, yes, yes. I don't go anywhere either, darling. I left the house today, to go and get my lashes done, but that was under sufferance. And yeah, I can't wait to get home. I get social anxiety pretty much. And I was it was funny because, as I said, I don't normally go onto X or Twitter or anything like that. And I did so yesterday because I realised that they have the most up to date stuff on what's happening in the trial. So that's how I realised that it was set for today, because they have like minute by minute. Someone's in the courthouse tweeting what's going on in real time. So well, you're right. There is no place like home. I've got everything set up exactly how I need it here for me to cope the best. Well, you can see the state of my hand. Oops. And I think that's why I like YouTube so much, because to most people, no, I've got it, but I don't use it. I just post my streams to Facebook. But unlike people like you, my OGs, everyone else, I'm not the disabled neighbour. I'm not the disabled daughter. I'm not the disabled sister. Do you know what I mean? I'm Jody, and you can only see pretty much from the neck up, and this is the bit that still works. The rest of me's fucked. And I think that's why I enjoy live streaming, because I get to be me again without the disability attached to it, if that makes sense. Because my mum keeps saying to me, what's so good about it? It's because it's me. Yep. Oh, that's what I was saying. So I was on Twitter this afternoon, and this Curly, the new girl that that was online with us when we started following me on there, because I had posted that I was, doing live streaming the trial. And so I'd written in the time zones. So, it was going to start at this time, Eastern Standard Time, this time, Florida time, this time, Melbourne time. And she commented by saying, "Oh, thanks for putting Melbourne time in there. I'm just getting off a bus and the weather is disgraceful." And I'm like, "Well, I put Melbourne time in there because I'm from Melbourne." And that's how she found me. But then I went and had a look before whilst the trial was on, and I actually clicked on her name and started following her. She is an arthritis sufferer as well. Go figure. Go friggin' figure. And of all the people that are on X, are on YouTube, not only does she find the Melbourne, and I bet you if I ask her, she's probably around the corner. Yeah. So I'll be DMing her later. Probably tomorrow though. I'm gonna sleep for a little bit. Yeah, you funny cat. You're a funny kitty, aren't you? What is wrong with these people? Oh, fuck off. Really? No. Oh, all right. We're 20 minutes behind. Oh, fucking hell. This is about my new where on my other knee. Yeah. 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 I hears ya. I hears ya. My old body don't work anymore. Not at all. Not at all. I can't believe we've missed 20 minutes because I didn't refresh it. Yeah, that's pretty much what I want to say. Oh, want to watch the actual trial and not the cat asleep on my hand.
20 CF 2603. Can I get appearances for counsel for the record, starting with counsel for the state?
Chief Justice on behalf of the state, William J. for the state.
Defense.
James Older for Sarah Boone.
Tony Henderson.
I'm an idiot.
Ms. Boone is seated at counsel's table wearing the same black suit and pink blouse from this morning. State, anything we need to address before we bring back in our panel?
Can we get the evidence projection system up and can we test it before we
Yes.
go live?
Yes, sir.
Oh. Oh, that would have. Oh. Oh, that's awful.
If you want to test it out, Mr. J.
Well, I was what are they doing? I was normal until 2014, and I got a urinary tract infection that went to my kidneys, so it became pyelonephritis, and ended up having to go to hospital for IV antibiotics. It was that bad. I was in like fetal position in so much pain, and the back pain never it reduced, but it never went away. So they kept putting me on antibiotics, thinking it was still this kidney infection, even though they were testing and there was no bacteria or anything coming up. And so they just started investigating further as to why this back pain was going. And apparently I had a dormant gene that was triggered from this this infection. So it was a genetic predisposition for psoriatic arthritis, and yeah, just got triggered overnight pretty much. And it is it's like the sister of rheumatoid arthritis, so it has pretty much the same degenerative, ongoing chronic symptoms, same as rheumatoid. Basically, the only difference between the two is that my symptoms can happen on one side only or both sides, whereas rheumatoid, it is universal. It is like both sides are equal. But it's not a well-known variety. It's not your garden variety arthritis. So the funding and support out here is bullshit. I'm nearly at the point of needing a carer because standing is just really bad. My spine is like honeycomb. So yeah, all right.
Programs, so they're here just simply to observe. So pay no mind or attention to them.
And I
With that,
students
are we ready
in
to
there.
bring in our jury?
Yes, Your Honor.
Bring the jury. Come
All right,
on,
let's stand and bring in our panel.
let's go. Let's get it on like Donkey Kong. So yes, I feel you.
Members of the jury, good afternoon. I hope you enjoyed your lunch. If you could, again, by a show of hands, confirm that you complied with the court's instructions that we gave prior.
Luckily, when you are eligible for the disability pension over here, you are covered for quite a bit of stuff as far as medicines goes, as far as, doctors goes. They pretty much have to bulk bill you most of the time, but specialists, no. I just paid $1,250 to a psychiatrist to assess me for ADHD, to tell me that I was suffering from grief for the loss of my independence. I could have told you that, dickhead. $1,250. Which, what's the conversion rate? I think there's, can't remember. It was a lot though. Not happy.
Yes. Sir, good afternoon. You could be seated. After
What's
seated,
his
if you
name?
could please
Shelby?
state and spell your name for the record for us.
Brian Boone.
Oh, my husband, ex-husband.
B-R-I-A-N-B-O-O-N-E.
Thank you, sir. You may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you know the defendant?
I dated her for quite a while, and then we eventually got married.
When you say you dated her for quite a while,
Yeah, it isn't.
how long are we talking?
I met her in the late 90s, and I believe it was around 2005 when we got married.
Did you have any children as a result of your marriage with the defendant?
Yes, we had one son.
Lucas?
And how old is that son?
He is currently getting ready to turn 14.
Did your marriage with the defendant last?
No, it did not.
And approximately when was it that you separated and began proceedings for divorce?
Probably 2017.
Yeah, I think
thinking
Sarah
maybe.
was having an affair with
At that time,
George.
When was your divorce actually finalized?
Oh, maybe it was 2006. I think the divorce was 2017. I believe.
I couldn't tell you when mine was.
After your divorce, what was your custody arrangement with your son that you had in common with the defendant?
She was supposed to have him on Mondays and Tuesdays. I would have him Wednesday, Thursdays, and then we'd alternate Friday through Sundays every other week.
So 1 week you would have 5 days with your son, and another week she would have 5 days with him.
Correct.
And was this still the same custody arrangement in February of 2020?
Yes.
And in February of 2020, did you have, do you recall the events that occurred, I guess, first on the late evening of February 23rd, 2020?
On that evening?
Yes.
Well, apparently Sarah called me at one point during the night.
Do you recall about what time she called you?
I think it was 11 something.
When you
Was she off her
answered the
face?
phone, how did Sarah sound on the phone?
She sounded like she had been drinking, was pretty drunk.
Were you able to understand what the defendant was saying?
Somewhat, but she woke me up. I had work the next day. I was asleep when she called. She's done this before, calling me late at night, and generally I kind of just try to ignore it, so I wasn't really paying attention.
He's pretty tolerant, really, isn't
Who
he?
was she living with at the time?
Jorge Torres.
When she called you late that evening, could you hear George in the background at all?
Not that I remember, no.
Did you pay much attention to this phone call?
No.
Now, the following morning, on February 24th, 2020, did you begin to call the defendant?
Yes, I did.
And approximately what time did you begin to call the defendant?
I think it was like 11 o'clock or something.
And why was it that you were calling?
Well, it was going to be Monday. I had him on Sunday and dropped him off at school, and I was calling to try to find out if she was going to be actually picking him up that day.
Why would you have a question about whether or not she was picking him up?
She wasn't generally very good about actually getting him on the day she was supposed to.
So it was not uncommon for you to have to remind her to pick him up or to make sure that she was going to pick him up?
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
Unreliability.
Do you remember at what time on February 24th you actually got in touch with the defendant?
I think it was like 12:30 or something.
Yeah, she didn't ring 911 till
When you
1 o'clock.
actually got in touch with her, what did she tell you on the phone?
That George was dead, and if I would come over.
Did she say what happened to him?
I don't remember if she told me then on the phone or when I got there, but she told me they had been playing hide and seek and that she fell asleep.
I couldn't tell you one adult that I know that plays that.
I told her she needed to call 911 and that I would come over as soon as I could.
And this is on your first phone call here at approximately 12:30.
Yes.
On 2/24/2020.
Yes.
Did she call you again while you were en route to her residence?
Yes,
She did. She called to find out if I was still going to be coming over.
And when you spoke with her
Needy.
while you were en route, what, if anything, did you advise her?
I told her she needed to call 911 and told her I was on my way, but she needed to get somebody over there.
How long did it take you to arrive at her residence?
From the first phone call, or?
Yes, from the first one.
Well, I mean, I live a minute or two drive away, but I had to get my puppy. We had just gotten a puppy recently. I had to get him in his crate and stuff like that and put something on because I was working from home. And total time, maybe 10 minutes.
When you arrived at her apartment, tell us what she told you when you arrived.
I mean, George was dead, and once again, I don't remember if she told me now or before that they had been playing hide and seek and she fell asleep. But I, at that time, told her again she needed to get 911 called to get somebody over there.
Had she called 911 at this point?
No, she had not.
So you've advised her now 3 times to call 911.
Yes.
That's you. That's mine. It's my strawberries.
Did you go inside of her apartment?
I walked in the front door into the little tiled area, like entranceway thing.
What, if anything, did you observe when you made it to that point?
Looking into the living room, I could see like the end of his feet and maybe a little bit of some legs that were kind of coming out around the backside of the kitchen area.
Did you continue to go into the apartment?
No.
Where did you go?
Sarah told me she was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her. And I told her that I didn't really feel comfortable being inside. And I went out front and got in my car and waited for people to show up.
Did you witness the defendant call 911?
I think I was in there when she dialed it and first got somebody on the phone, but I wasn't there for the whole conversation. No, I was outside.
stay there at the scene while police arrived?
Yes, I was there. I was part of it. I knew I'd have to talk to somebody, so
Did you talk with law enforcement?
I did.
Your Honor, I have no further questions at this time.
Thank you. Any cross-examination?
Judge, we want to reserve our questions for when we call him in our case.
Told you. Yep.
Okay.
They want to hold
All right,
back.
sir. You're subject
They're
to recall.
holding their
Okay,
cards
thank
close
you.
to their
Thank you.
chest. They're letting the state dig themselves in.
Just as long as he remains under subpoena.
My understanding is subject to recall.
So somebody will contact me about that?
Yes, sir.
Thank you.
Thank you, sir.
Yeah. Look. Yummy. Yummy. Yum, yum.
State, you may call your next witness.
Your Honor, may we approach a moment?
Yes.
Ugh. Cat's eating half of my bloody yogurt. All right, L. Nope. See, you've made a big mess. Right, let's L. Why? Because we can.
Evidence that's been received so far. Mr. J, whenever you're ready, sir.
Delicious. Look at that.
You may do so.
Mm-mm-mm.
It's 300 minutes. Call on Monday, February 24th, 2020.
911, what is the location of the emergency? 4748 Frank Court, apartment 3. 4748, what's the street name? France, F-R-A-N-T-Z. And the appointment number? 3. Is this a police or medical? My boyfriend is dead. Okay, 7-11.
Sounds super upset, doesn't she?
Not hang up.
Location, Murphy.
That's good. No, please don't leave. 4748 France Lane, apartment 3, France Court.
Yeah.
France Court? Yes.
Okay, is this near Mackenzie Drive?
I don't know where that is.
Okay, okay.
It's Gilwood Park Apartment.
Okay, 4748 France, correct?
Correct.
All right, correct. Now tell me exactly what happened there.
My boyfriend and I were playing last night, and
Mm-hmm.
I played him in a case when we were playing, and
Okay.
but kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase. So I don't know what happened. I don't know what happened.
Right, okay, what's your apartment number?
3.
Apartment 3?
Yes, like he had like blood coming out of his mouth, and I don't know, like he had like an aneurysm on what happened.
Right, okay, all right, okay. Listen, we're getting up to 13. All right, okay. Okay, I.
Now?
Blood
Okay,
coming out of his
okay,
mouth.
so we're on our way up there. You're at 407-716-8684. Okay, you hanging from somewhere or what, man?
No, I pulled him out of the suitcase. I tried giving him CPR.
Okay, so he was in a suitcase?
Yes, and I fell asleep.
Okay, how old is he working there? 42-year-old man. All right. Okay, we're setting up, the sheriff's officer out there?
Yes, sir.
Yeah, okay. All right, listen to me. Okay, that you need to confirm this. No, right, I just need to confirm this. Is he awake at all? Is he conscious at all?
No, he's purple.
Is he breathing?
No.
All right. I need you to get him on the floor, flat on his back for me, okay?
I did. I tried giving him CPR.
All right.
I tried giving him CPR.
Yeah, okay, well,
No, nothing happened. He's purple.
okay, listen, is it a definitive
in the bill. I need you to get it for me, okay?
What is
Do
it?
you have the AED available?
No.
All right, you're right by him now.
I'm sorry?
Are you right by him now?
Yes.
Okay, okay, ma'am, listen, so this is he cold and stiff?
Yes.
Okay.
Well, it's not necessarily cold, but it's stiff.
Right, okay. All right, listen to me. Listen to me. I want you to lay flat and back for me on the floor.
I did.
Removing the pillows, okay?
Yes, I did.
All right, okay. Wait.
Stiff and purple.
Right, okay, listen, okay, man, that's fine. We're still going to put two compressions on him, okay? All
Oh
right?
my God,
Really?
really?
You look your hand on his breastbone, right inside of the chest, right between the nipples.
Rigor mortis sets in, I think, between 2 and 4 hours. Oh, and you want her to do chest compressions? Really? He's stiff.
Yes.
Put your hands up on that hand.
Baby, I'm telling you. Just like that, you can tell.
Okay.
Please, okay, your girdle.
Okay, okay.
Yeah, you're just going to be pushing
All right,
fluids around
I want
now.
you to place the heel of your hand. Okay, right between his chest, right between his breastbones. Put your other hand up on that hand.
Yes.
We want to pump his chest to be hard and fast.
No, you don't.
Going to twice per second.
I'm doing it again.
Okay, no, just keep on pumping. That's all you need to do for me. Keep on pumping his chest for me. I don't need you to stop and talk or anything. I just want you to count out loud for me, okay?
1, 2,
Yeah.
3, 4, 5,
Too slow.
6, 7, 8, 9, 10, 11, 12, 13, 14, 15. This is nice to me.
Okay, man, just keep on pumping his chest. That's all you need to do for me, okay?
Yes. Come on, please, hurry up.
Okay, ma'am, they're driving here as fast as they can. Okay, don't stop to say hurry up. Just keep on pumping and counting.
I'm still doing it while I'm talking to you, okay?
Okay.
Still doing it.
All right, just keep pumping his chest. Count on, I'll take a count with you.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16,
What, no breath?
17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31.
There's no point doing
Please
chest
hurry.
compressions if
Okay,
you're not.
man, they're getting here as fast as they can, okay?
Still, he's purple.
Okay. Keep pumping his chest for me, ma'am.
I'm still doing it, okay? Still doing it. Still doing the concept.
Right, okay, that's fine. You did a good job. Just keep on doing it for me. That's all right. They're getting there as fast as they can. I'll always the sheriff.
911.
Okay?
Please.
A 911 operator's like trained to tell anyone to do CPR over there. Like, obviously, if he's stiff and cold, maybe it's just me.
Keep on pumping, man. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. Keep on pumping for me, man.
I'm doing it. Believe me, I'm doing it, okay? We're going to play hide and seek.
Oh. All right, I understand. All right, just keep on pumping for me, okay? Okay.
Please hurry.
Right, okay.
Horrible. This is horrific. What happened? Like, what happened?
Okay, man, keep on pumping the chest for me, okay? They're in the parking lot. They should be up there shortly, okay?
I'm still doing it, okay?
All right, okay, good. And you found them in a suitcase, you said?
Yes. We were playing hide and seek last night. I fell asleep. I think they're here.
All right, just keep on pumping the chest until they push over, okay?
I am.
Okay.
I am.
Okay.
I am.
Okay.
Okay. Come in.
All right. Let me put this to you. If you had the intent to unalive someone, surely to goodness you would think of something far easier. You wouldn't think, right, I'm going to unalive someone. What is the weirdest thing I could do to achieve my goal? That, to me, eliminates premeditation right there.
Let that take over for you, okay? What was the last time anybody saw him? The last time. We'll play hide and seek. He was the Virginia. Okay. But unfortunately, he's been down too long to have to keep recording. Hello, ma'am. So we're there, obviously. All right. No, I'm trying to figure it out. Okay. Is there anything a little? No, not that. Hello? Hey, man, is this not going to take care of you, okay? Okay, so we'll see you there. All right. Oh, ma'am, is still there? Hello? Calling back 407-716-8684, reference to mobile data. 1308. Call has been forwarded to an automatic voice message system. 4.
We're ready to continue with the presentation of witnesses.
Yes, sir. You may call your next witness.
State we call Abraham Moreno.
Abraham Moreno is a neighbor and friend.
Mr. Moreno, raise your right hand and sworn, please. Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm. Sir, good afternoon. Could you state and spell your name for the record for us?
Abraham, A-B-R-A-H-A-M. Last name is Moreno, M-O-R-E-N-O.
Thank you, sir. You may be seated. Mr. Cacciatore, you may inquire.
Good afternoon,
Cacciatore.
sir.
Good afternoon.
Tell us, what do you do for a living?
I'm a maintenance supervisor for apartment complexes.
Is that what your position was back in February of 2020?
Yes, it was.
And what apartment complex?
Tealwood Park Apartments.
And how long did you work for Tealwood Park Apartments?
About 2 years.
And tell us, what were some of your duties in your position there with Tealwood Park?
Daily, I cleaned the grounds, walked the property, answered maintenance calls, did emergencies, dealt with vendors.
Did you become familiar with the residents there at the apartment complex?
Yes.
Did you have occasion to meet the defendant in this case and also a Jorge Torres?
Yes.
Let me turn your attention to February 24th of 2020. Do you recall that date?
Yes.
And on that date, did you have occasion to come in contact with the defendant in this case?
Yes, I did.
And tell us, what was the circumstances in which you came into contact with her on February 24th, 2020?
I was called by the manager and the assistant manager to come to her unit. I believe she was already sitting outside at that time.
And when she was sitting outside of her unit, what, if anything, did you observe about her and about the unit?
The police was there. Her ex-husband was present. She was sitting outside, and that's when she decided she wanted to talk to me and the managers.
And what did she tell you?
That she's confused. She's not exactly sure what happened. She pointed out that she recalls that they were playing a game of hide and seek. There was an instance where she was going to teach him a lesson, and then she just doesn't recall anything else until the next morning.
Did she say she fell asleep?
Yes, she did.
Did she say things got out of hand?
I don't really recall that part, but I do recall her stating that they were playing their game and that George went into a suitcase, and I didn't ask any questions. I just let her talk for herself
How long was this conversation?
for about 4 or 5 minutes.
Your Honor, I have no further questions at this time.
Any cross-examination?
At least they're not dragging it out.
Yes, sir.
You may inquire, sir.
Good afternoon, sir.
Good afternoon.
This conversation that you had with Miss Boone,
Yes.
that took place on the 24th? Is that correct?
Yes.
And who else was present on the time that the conversation was taking place?
Her ex-husband, you said.
Standing right next to me would have been Melissa Sexton and Eugene Harris, as well as the officer who was in front of the door.
Okay, so there was a law enforcement officer there that day, is that correct?
Yes.
Didn't you say the ex-husband was there too?
Now, on the 24th is when you said that Miss Boone made this statement to you. Is that correct?
Yes.
They were playing hide and seek?
Yes.
And what else did she say happened?
She had told me they were playing hide and seek. They had drank. She was trying to teach him a lesson, and that was that. She went upstairs. She went to sleep. She woke up. She doesn't know what happened.
Okay. So that was on the 24th?
Yes.
All right, on the 26th, were you not interviewed by law enforcement?
Yes.
Okay. So
I may have my days wrong, but it all happened on the same day.
All right, the 24th, do you remember 2 days later that a Detective Scott Lowen conducted an interview with you at 4704 Lucier Court, Winter Park, Florida? You remember that interview?
Yes.
So that was 2 days later, is that correct?
I would assume so.
Yes. All right, so
Uh-oh. What are they going to
when
impeach
he
you on?
interviewed you 2 days later, did you tell him about this statement that Miss Boone made to you that you just told this jury in
Going
court?
to teach him a lesson?
I did mention it to him.
You did mention it to him?
I mentioned to them that we did have a conversation.
Did you tell him the content of the conversation?
I may not have told him the whole content, but I did tell him we had a conversation.
All right, well, what did you tell him?
Deposition
what content
doesn't
did you
have
tell him on the
that information
26th?
in it.
That they were playing hide and seek, that she was confused. She doesn't know what happened.
That's not the
I
bit
believe
they're
I did mention
after.
to him the fact that she had said that she was trying to teach him a lesson. Not that anything was done with malice. I didn't state that at all.
So it's your recollection now today that on the 26th, you told Officer Lowen what you just told this jury. Is that correct?
Yeah.
All right. Sir,
Here's the deposition.
in preparing for this case, did you have a meeting with the Assistant State Attorney on September 23rd of 2024?
Did I have a meeting?
Yes.
A brief chit chat over the phone.
A brief chit chat was over the phone?
Yes, sir.
All right. At that point in time over the phone, did you tell him that Sarah Boone, the defendant, stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
Yes,
Is that what you told him?
yes,
Okay. And that was in 2024 of September the 23rd of this year, 2024. Is that correct?
yes,
Are you telling us that back on February the 26th of 2020, you told Officer Lowen at that time the same thing?
no, as I recall, yes.
Get on with it, councillor.
So did she ever tell you how things got out of hand?
It's at 1.25, seeing as we're half an hour behind.
Sir, you
Fairly
testified that
slow.
you knew both Mr. Torres and Miss Boone, is that correct?
Yes,
You actually knew George Torres from a different time, didn't you?
yes, I did.
When did you first know George Torres?
In the 1990s.
In the 1990s?
He was a teenager and he lived down the street from me and my wife.
So you had had a previous relationship with Mr. Torres?
No, not at all.
Not at all. You just knew him from then?
Yes, as I stated, he was a teenager and I was an adult.
During this time, though, that you became reacquainted with him, did y'all establish a friendship at that time here in Orlando?
I wouldn't say a friendship, but an acquaintance, yes.
Where are you going with this?
Sir, on Monday, February the 24th, that would have been the day that you were with Ms. Sexton and Gene Harris.
Yes.
Out in front of the apartment.
Correct.
Did you talk to law enforcement that day?
No.
You did not talk to them that day?
I don't recall talking to him today, no.
Okay. Thank you, sir. I don't have any, if I can confer.
You can, sir.
Thank you, sir. I don't have any further questions.
Any redirect examination?
Just brief.
All right, thank you.
Back in the 90s, when you had previously known George Torres, in this case, where were you living at that time?
I lived across the street. I lived on one block. He lived the next block over down in the middle.
In what city?
Philadelphia, Pennsylvania.
And when did you move from Philadelphia, Pennsylvania?
2018.
So in the intervening years, from your move from Philadelphia to coming to work at Tealwood Park, did you have any contact with George Torres?
No, as a matter of fact, I'm from that particular block in 2005. So I don't meet Judge again until I work at Tealwoods.
When did you start working at Tealwoods?
2018, 2019, roughly there.
No further questions.
Can this witness be released?
No, Your Honor, just subject to recall.
All right, sir.
They're going
You'll
to
be released
hold
subject to recall.
every one of them.
Thank you.
State, call your next witness.
State will call Deputy Kayla Rodriguez.
They are, because they don't know what they're testifying to. So they're just going to hold every one of them and keep their cards to their chest and play it safe. And any little bit of information they can get out of them for recall, they'll get it.
Good afternoon, ma'am. You can be seated. Please state your name and spell it for the record if you could for us.
Kayla Rodriguez. Kayla, K-A-Y-L-A.
Fine by the
Rodriguez,
seat of their
R-O-D-R-I-g-U-E-Z.
All right, thank you.
Had enough
Yes,
time
Jorge, you
to
may
prep.
Good afternoon, ma'am.
Hi.
Can you tell us did you work for?
Orange County Sheriff's Office.
And what is your position with the Orange County Sheriff's Office?
Deputy Sheriff.
And how long have you been a deputy sheriff?
A little over 8 years, since 2016.
And tell us, what are your duties as a deputy sheriff?
As a deputy, I respond to calls for service, anything from a over with call, like a car being keyed the day prior, or a 911 emergency.
And what type of training do you need to be a deputy sheriff?
So for me, I obtained my bachelor's degree from UCF in criminal justice in 2014. After that, in 2016, I was hired by the sheriff's office. Right after being hired, I went straight into the academy. The academy is 5 months of training. We go over everything from case law, scenarios, defensive tactics, physical training. After that, I do 2 more months with the sheriff's office where we go specifically into policy related to Orange County specifically. After that, I do 3 months on the road with a trainer where we are evaluated periodically through that process. You have a partner, you respond to calls for service during that time, and you slowly learn how to handle calls by yourself.
February 25th, did you receive a call in regards to this case?
Yes.
And what was that call? What information did you have at the time you received the call?
So the dispatcher informed me that a woman called 911. She was actively performing CPR and that her boyfriend was in a suitcase.
And did you respond out to the scene?
Yes.
And when you responded out to the scene, were you dressed similarly as you are dressed today?
Yes.
And just for the record, you have, it looks like a standard green uniform on with a tool belt, your firearm, and also
And a
radio,
green thong
body-worn
over the
camera,
top of it.
badge.
Yes.
Tell us about your body-worn camera.
So my body camera is used to capture scenes when we arrive. So as we are conducting any sort of law enforcement action, we turn our camera on.
When you turn your camera on, tell us, does it immediately capture sound
No.
at that point?
It does not. When we activate our camera, it goes back a minute. And the minute that it goes back to, you don't hear any audio for that first minute.
Tell us also about the capacity and the battery life of your camera as well.
So the battery will last us an entire shift, typically, if it's in a buffering mode. So if we're not recording, it will last the entire shift. As we record, it does drain the battery. So typically we will turn it off if we're sitting in our car for an extended period of time. If we call our supervisor, if we're talking to another deputy on the side, away from a scene, we will not have the camera recording. If it recorded throughout the entire shift, the battery would die. We would need multiple batteries.
So you actually activate the
What
camera
you do?
in order to begin recording.
Correct.
Was your body camera operational on this call out?
Yes.
Those cameras shouldn't be able to be manipulated manually. They should be automatic so that they can't turn them on and off as they see fit.
Your Honor, may I approach the witness, which was previously marked for identification as states H, I, and G?
This will be the
that have been shown to defense.
body cam footage.
Ma'am, I'm first showing you what's been marked for identification as states I.
Yeah.
Recognize that February 24th. All right, this time,
Permission to publish.
can you take a look at that? Yes.
Come on.
This camera.
As states H will be received.
Mm-hmm.
Do you recognize this?
Oh my God, how many videos have we got?
Your Honor, may we dim the lights and use the overhead projector?
Yes.
You live here? Okay, I'll talk to you guys. Okay, kind of like, the property manager, I will have to go. Tell him really quick, or what's going on? Where's, yeah. You want that? Oh, don't worry about that. We'll take care of that for you, okay? I had a cigarette.
24th of February 2020.
I really.
At,
Okay, well, I got my dog on the counter. Okay, you want that?
let's see the time.
For the time. You got time, okay.
11:48. No, that shouldn't be the time.
Who's he you? Boyfriend? Yes, because of like 3.5 years. What happened? He and I, we drank last night and had a. Can you pass this to the, around to the FBI stuff? They need to sign out, sure. No, you two then have to, this might be a real thing, but each of them has to put their name.
I just put everything. Yeah, you know,
What's going on? I decided to fill in. No problem. Like, puzzle together, we can do some artwork.
Slow that down a bit, sorry.
Yes, we have a puzzle that we started.
Probably why I can't understand it.
New art, apparently, having a good time for another, but we're drinking, we had a bottle of wine last night. So then it's like, we decided to play hide and seek, right? Okay. So he gets in the suitcase, okay? That's my ex-husband, my former husband. How did he live till we got? No, I called him over here. Okay. I didn't know what to do. Okay. I didn't know what to do. Okay. So then he came over here. Here, let's talk inside. Okay. I called you guys. The problem is, I fell asleep. When did you do CPR? This morning. When I found it before you called. Yeah. 1 o'clock right now. I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs and I was like, oh, he's in the suitcase still. That's when I found him. I took him out and I tried doing CPR and then I called him and then I called you guys. Did he get here before the fire department got here? Who? Your husband? Or your ex-husband? Okay. Where did you live at? Right on the street. Okay. So you were playing and who did some updates? I did, but then I fell asleep. Okay, stop. You're okay. I wasn't there. I'm just trying to figure out what happened. Like having aneurysm or a heart attack or what? What kind of medical condition? None that I know of. None that I know of. No. All we had was a bottle of wine. Literally, just a bottle of wine. Okay. Doing puzzles, artwork.
So later bottle of wine.
What have you seen? That's all that happened. Okay. But I never had a attack or what in there. Like I don't know what happened. So how long were you doing CPR on him prior to you calling 911? You tried that all morning? Yes. Okay. And then I called him while I was did you start probably doing your ballpark? Here, let me fill this step in, okay? Please, may I have my Dr. Pepper? I am still cutting out right now. Ma'am, and you can't talk to him until we get down to paper, okay? Just don't leave, okay, Ryan? Thank you, ma'am. Appreciate it. Thank you. I know. Do me a favor. Stand over there by that part. Give me 1 second. There's a dog in there? Yeah. You want to clear the back bedrooms real quick? Just make sure there's nobody else in here? Is he here by himself? Nope, he was here with the girlfriend, and that's the girlfriend's ex-husband. He's going to see it. They were playing out and go see what she said. She's been doing CPR on him all morning before calling us. Yep. So I'm going to go ahead and start making phone calls. Okay, go ahead. What do I do with this dog? Because I don't want him to mess with him. Come here. Oh, perfect. Okay. Yes. Hey, come on, let's go outside. Come on.
Good boy.
Cutie. You think about it, but just want to make sure. I'll put my glove on. Touch anything.
Orange County.
Yes, Right over here. We check this closet. So garage. That's garage.
I guess we're gonna have to set up a crime scene now.
Oh,
What's that? 10-20, 10, Cook, 10-20.
just give us a second, okay? It's on the counter. I can't move it. You can come out of the house. Here, let's get you down, because I don't want you passing out. This is probably a lot for you to deal with, right? Water. I can get you some water, okay? Just, I want you not on your feet. I don't want you passing out. I need to find water. Okay, I'll get some for you.
Your Honor, request permission to publish States 5.
You may proceed.
Let's go ahead and start making the call. Yes, could you go ahead and give me his last name, Torres? Spell it for me. Torres. And his first name? George, Jorge. Jorge. His birthday? 2/13/78. And this is the boyfriend? Yes. How long? 3.5 years. Living together that whole time? Yes. Okay. And your last name? Boone. Spell it Boone. First name? Sarah. Sarah. Birthday? 10/10/77.
10/77.
So you had a second to kind of collect yourself. Tell it to me again. You guys were playing last night, drinking a bottle of wine, putting puzzles together, doing artwork,
We had a bottle of wine and they decided to play hide and seek. So he
What
would,
time was that? Do you remember?
I mean, I know that I was in bed probably by like what, 12:30?
Okay.
Well, I went upstairs at least and I fell asleep. Forgetting that he was
So
in
you
the
guys were
suitcase.
playing the hide and go seek?
Yes.
And at some point you put him in the suitcase?
No, he got in the suitcase. So he thought it'd be funny to be put in the suitcase. So I was like, okay, well, I'm gonna joke with you and I'll zip you up and make him, squirm a little bit, whatever it is. But then I fell asleep. I fell asleep.
Where was the suitcase?
Right where it is.
Right down there?
Yes.
You zipped him in there?
Yes.
Thought it would be funny a little
It
bit?
was. We both were laughing about it. And then
Okay.
I fell asleep
Where did you fall asleep at?
upstairs.
In your bedroom?
Yes.
Okay,
Totally forgetting that he was in the suitcase still.
okay. And then you came back downstairs?
This morning, or this afternoon, yes, when I got up.
Ballpark, what time?
12:30-ish. I was awake, but I totally forgot that he was in the suitcase. He can tell you there's a lot of things that we can go jobs,
Yeah, he did tell me.
bikes, all that good stuff. So I just
So
totally
you
forgot.
began to do CPR on him?
Yes. Yes.
About
And he
what
gurgled.
time this morning
He
did you
gurgled.
start doing that CPR?
No, it was the afternoon. It was afternoon because I was awake. But then I finally decided to come downstairs at like 12:30-ish, whatever it is. And I was like, I think he was in the suitcase. And he wasn't moving. Nothing was happening. So I unzipped him, took him out and started doing CPR on him. He was on his way up here. I called you when he got here.
Once he got here, you called us?
Yes.
Okay.
And air was coming out and he was gurgling, but I could just tell by looking at him.
But you knew how to do CPR, you were doing that on your own?
Yes.
Okay.
And then the person that was on the phone with me also, I counted with him doing it.
And he's got no medical, he doesn't take any
I
medication?
don't know, I don't know medical wise, I know he doesn't take any medications whatsoever. The only thing, like I said, I don't know if alcohol had to do with it, but we had a bottle of wine.
Okay, all right. Here, I want you to sit back down, because I don't
Can I
want
have one more sip of water?
Yeah, go on. I'll do what I can to get you a cup, because I don't want you to have to keep doing that.
The cups are like right there.
Sit right here, don't talk to the ex-husband right
Oh, I
now.
won't, I won't. Can I have a cigarette, please?
Ma'am, I can't take anything out of the house.
It's on the back porch.
Nope, all of it, secure, okay?
I'll try my best to get you what you need, okay? Maybe one of these days you'll have a pack from someone, you know, sit down and I'll try and get you what you need, okay? Just cut, please. Okay. I don't want you on your feet. Yes, you put him on the side. He came back in? So there's no thanks then? Corporal, I can give you a rundown? She's, sitting on the curb at home, I was getting ready to call you guys. Yeah. Want to talk over here?
Your Honor, request permission to publish State 6.
You may do so.
Jesus, that beep is loud.
You get enough water? No, you want to stay seated. I don't want you getting lightheaded. So remember I said the detectives were gonna come out and talk to you and go from there. You know what I'm saying? They're here. They're gonna ask you a few questions and then go from there, okay? All right.
All right, sir. My name is Chelsea. My partner Scott. It's my understanding you reside here? Okay. Is it just you? Okay. Your former husband. Okay. But you reside here with George, and then your son lives with you, or lives there's 50-50. Yeah. Okay. So from what has told me, she explained last night that you guys were drinking a bottle of wine, and around midnight, you decided you guys. Okay. You guys decided to play hide and seek.
Well, we were playing hide and seek, and then.
Was your son home at the time, or okay?
No, it was mine. It was fine.
Okay.
Decided to play. We just did it like that. Like, sure. We were putting puzzles together. We were doing artwork. You can see the puzzle that we finished in there, and then the artwork, and then decided to play hide and seek. Just being stupid.
Okay.
So he decided to get in the suitcase. So I thought it would be funny to, and he was talking about it too, to get him up in there. I go upstairs and fell asleep. So this morning when I got here and I actually got up out of the bed, I got sure he was downstairs on the laptop, really quiet. But then I came upstairs and I'm like, where is he? Like, and that's what I found it.
Okay.
I don't know what happened.
Okay. And then you weren't sure about if you woke up this morning.
It was afternoon. I mean, I was
or this afternoon.
But I just didn't want to come downstairs. So I just laid in bed for a little while. And then I eventually came downstairs. He was where he was. And I was like, oh my God, he's in the suitcase still. So I pulled him out and I just ripped him out. And I started to try to make CPR for him. I called you guys. So I called Brian. Okay. And then as soon as he got here, which is 30 seconds on the road, I called you guys.
Okay.
The
obviously have to go inside the house. We have to look at things. Are you okay with us going in the house and looking at things? Okay. And forensics, so we have to have our forensics crime scene investigators come out. Are you also okay with them coming inside, taking photographs and? Okay.
Can I ask, is Brian, sorry, George, was he diagnosed with any kind of mental history?
Not that I know of. Not that I know of. I don't know. I mean, it doesn't take drugs. I mean, we'll have you take a bottle of wine here and there, but I don't know, like.
Well, that would be my next question. So you guys don't normally drink, you just drink once in a while, or?
Well, I'm gonna say, like, okay, I guess normal drinking is, like, we will have like a glass of wine or two, like, while we're cooking dinner, or church, beer, and we'll say, that's working with him, we'll be right there. But it's not like.
Couple of beers a day?
I don't understand though, like, for the little bit that we had, like, not high. Like, I don't know if they had a heart attack or a stroke or anything, or what happened, I don't know.
So were you guys together all day yesterday? Okay. Here? Like neither of you left the apartment yesterday?
I think we rode up to the before to get cigarettes.
Okay.
But you can walk there.
Does he have any history? I know he doesn't now, because you said he doesn't,
I
right?
don't know.
As far as you've ever known him, you've never seen him?
No. I mean, he's from Philadelphia, and he grew up in Philadelphia, and then he went to Massachusetts, and then from Massachusetts he came down here. So I don't really know, like, a whole lot of, like, medical history or.
How long have you guys been together?
Almost 4 years, like 3.5 years.
You guys been living here the whole time?
Yes.
You've never been to the doctor or to the hospital during that time?
He and his brother got into a really bad argument at one point and had facial reconstruction. But he has been in the hospital from that, and then I talked him into going to see like a regular physician, so he could get just like a regular like checkup thing.
Yeah.
But there were no red flags.
How long ago was that?
The surgery or the doctor?
Both.
The surgery, I think, was at this point, what, 2 years maybe, 2.5 years. The checkup was probably a good 2 years too.
Okay.
And the suitcase is still in there?
Yep, all of it.
Is it normally stored down there, or did you guys travel recently?
No, he was gonna start picking from, what do you call it? Donation in there, so that's why
it's out?
Yes.
Okay, you guys did recently travel somewhere, anything like that?
After you zipped them up, did you move the bag around and mess with them at all, or you just zipped it up and walked away and out?
we're laughing about it, but I went upstairs and I fell asleep.
But what position was he in when you went in? Was he sitting on his rear end and his head up, and he just kind of
No,
up?
okay, so like this is the suitcase, like this is his head, and then he's right here, and his feet were down.
So he was laying on his side?
Yes.
You just closed the flap and zipped it around?
Yes.
Okay.
I was not playing.
Understand this? Okay.
So he said that I needed to tell you guys about his family. Like, who do I talk to about?
We're gonna do that once we walk through and see. Yeah, we're gonna.
I can tell you, like,
Yeah, it's gonna be a
I'm
while.
afraid for my life. I want you to know that. I am afraid for my life. His family has never liked me. I'm the blue-eyed white devil, is what they call me. So they've never liked me. They've never taken me in. They've never accepted me. I'll put it that way.
Have you called any of them?
We talked to his daughter just today.
No, I mean, like, about this. Is
No.
that, okay.
That's
So no one's gonna know until we will be making that notification, so
They're going to
it's,
tell me.
okay,
Do
well,
they live local?
Yes, they're down the road. They're going to tell me. His kids are going to tell me in Philadelphia. They're going to tell me. This was not intentional.
okay.
And they're not going to understand that. They're not going to accept it.
We're gonna do a thorough investigation and we will definitely make sure that you don't feel scared when we need you, okay?
And my 9-year-old.
Well, he's at school, I mean, he's with your husband.
I know, well,
Ex-husband.
Your husband said that, or your ex-husband said he made arrangements for your 9-year-old to be picked up.
Oh, okay, Mom. All right, we're gonna go inside. Yes, please, right. Can you guys keep posted? So I know what's going on.
Yes,
And don't.
All you have to do is get their attention if you have a question, you need to talk to us. He's standing right there, she'll be right here.
Yeah, okay, but when you guys tell me, like, so you're telling me, like, you won't call whoever it is without telling me, right? I mean, I have all their phone.
We're not calling, we're not making phone calls, we're actually gonna speak to them in person. We
That'll
are.
be later on.
Okay.
It'll be later.
Prior to us making any
I'm
calls.
not gonna be here. They're going to tell me.
We'll address all of that, okay, before we leave.
Okay? This was. Okay?
Okay.
Thank you. Just stay seated, okay, Sarah? I know you're panicking. Okay, just relax. We'll come and talk to you. We'll keep checking on you.
That was riveting.
From him as well?
I did.
Were all your interactions with the defendant on that day captured on your body worn camera?
Yes.
I have no additional questions at this time.
Thank you. Any cross-examination?
No questions, Judge.
Is this witness
Yay.
released?
Yes, Your Honor.
All right. You're released, not subject to recall, ma'am. Thank you.
Thank you.
Can the parties approach for a moment?
Hmm. L L L L L whoa. As we like looking at the back of Sarah's head.
3:21 at this
So
time. We're
much.
going to go ahead and take that afternoon regularly scheduled break.
Of course we
I'm
are.
going to ask you to come back here in 15 minutes at 3:37. Similar instructions that I've given you previously. Please don't just conduct any independent.
Right on. We have another break. So what's the time there? 3:30. So we've got an hour and a half more of testimony. You see the sun coming up in the background? Slowly but surely. All right, so we've been through. How many have they got here? One. Oh, no, that's not one. 1, 2, 3, 4. All right, the state has listed. 23 witnesses so far, and we have 1, 2, 3, 4, 5, 6, 7, 8. We've had 8 today, which isn't bad going. Isn't bad at all. But I don't know if it's the potential state witness list. It's not like the official one, I don't think. But what does the defense list say? How many have they got on theirs? 1, 2, 3, 4, 5, 6, 7, 8. But that doesn't include any of the people they've got subject to recall or the the ex-husband either. So who knows? Who knows? They could call anyone. Lindsay. I can't use my mouse properly because you're on my Mac. Oh, still got that up. Oops. What else have I got to show you guys? What is on my Google Drive? Not a great deal. Nothing that we haven't put say. Actually, what was it that I pinned? Oh, that was the time. That time conversion app that I put in, it's not, you have to activate it every time. Alright, so it's 3:38 in Florida. It's a sad face beside my Melbourne time at 6:38 because it's supposed to be normal sleeping time. Yeah, good thing I'm not normal, isn't it? I reckon we should do a raid. Who can we raid? Who's on live? Let's see. What is Mr. Baker? Up to? Hello there.
You can't get wrapped up in those lies because she knows she
What
changed
the
her
hell is
story.
Mo wearing? Those eyebrows.
Yeah, it really is. Again, her not taking the plea deal, I don't know what she's thinking. I don't know what the lawyers are thinking, taking her narrative as gospel. But this is not a good showing for any of them.
Mm-mm.
I do like that the judge is constantly asking, are you okay with this strategy that's going on? So she cannot come back and say, I had ineffective counsel. They were dumb. They were boobs. They were buffoons. They were duds.
Yeah, and
Because you know she's going to do that the very second she gets convicted, allegedly, possibly.
You know it because you know he's seen those letters she
boo
wrote.
boo boo, you know it.
Well, she writes a strong worded letter for everything, so you can only imagine.
Oh, I wonder if she's got like a Pop-Tart in the back or maybe like a PB and we'll just PB sandwich.
Maybe.
Like they're coming back.
Can't see what I can see. There's a silver dollar deadlift and there's a log press. Then I can't see what else is on the program.
A Sarah hurling event. We just get Sarah, throw her around like a hammer, allegedly in Minecraft.
That would be amazing.
I would love that. We would throw her onto bean bags. She would survive.
Well, it's in our old.
Oh, they are. That wasn't up this morning. Let's watch this one instead. This is different feed. I'm gonna have to change my. See that? See that subtle change there? I have an overlay for Law and Crime and an overlay for Court TV. Oh, that's right. My my the appointment that I had, the expensive one the other day, confirmed that I have OCD. Oops. Okay, that's yep. Look at that. Look at me go. There's no audio in the courtroom yet.
We are back on the record, case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Dave Kester on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone. Tony Henderson for Sarah Boone.
Yeah, we're back. Oh, yeah, Sarah Boone.
All right. Ms. Boone is still seated at counsel's table, wearing the same black suit and pink blouse from this morning. State,
Blouse.
anything we need to address
Blouse.
before we bring back in our panel?
Not from the state.
Defense.
No, sir.
All right, let's go ahead and stand and we can bring back in our panel.
I don't know if I can. I've been sitting too long. Literally. I don't know if I can. That's going to be fun when I go to get up. Didn't we just hear that? What the? I'm sure we just heard that.
Thank you. You may be seated. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Members of the jury, again, if you could please raise your hands, showing that you complied with the court's instructions during our last break. All right, the record reflects all jurors have raised their hands. State, you may call your next witness.
State will call Deputy John Martinez.
John Martinez. Ah, okay. Well, when I checked tonight, there was only the one channel that was streaming it. But thank you. Oh, what was this guy's name? Martinez, was it? Okay, he's law enforcement. No doubt. First responder.
Sir, good afternoon. Can you state and spell your name for the record for us?
Oh, I know why I'm here in double. I still have Baker's stream open in the background. Whoops. I'm going to need to go to the loo. I shall be back momentarily. You've got no audio. Yeah, no, it's on. I think it was like that first minute of the body cam, perhaps. Whew. Is this still the same witness, John Martinez? Oh, really? That's bizarre. I'll stop sharing and I'll restart.
Whatever you need to do.
About
Okay?
now.
We can talk about that more in the time. Right. Yeah, you.
But like, I don't, like, this was totally like not intentional. Like, that's what I'm scared about too. Like,
Beautiful. I don't know what happened there. Sorry, shut up.
What you're seeing here is common. This is us coming out. Yeah. It's a.
Did you have no audio for long? Like, or did it just go out just before I came back? Because I can go back if you want me to. Hopefully we weren't sitting there for 5 minutes going, doo-ba-doo-ba-doo-ba-doo-doo-doo. I don't think my stomach is very happy with me for some reason.
No real medical history that we know of. Where those who have passed away, we come out.
I know.
We come out to an investigation. Medical examiner's office, we send people out, this is what we do. If he was subject to
Sorry.
control and had a heart condition,
Mm.
we wouldn't be here.
I don't know what it is.
Exactly, and that's what we're here to find out, we're just here to get the answers. The answers that you want, the answers that the family
I just
want.
really want to see my son. I really need to see my son. I mean, I know I can't go anywhere, but it's right. So do I just like get out here and wait for you guys?
Yeah, you would, yeah, please.
Does anybody else have you to show up or wait here that needs to be here?
Ryan King's here, that needs to be here, the medical examiners will show up when we call them, but we're not ready for them yet. So they're gonna take him, they're gonna take some photos, take him, that's towards the end of it, and they'll be called well in advance when we're ready for them, but we're not ready for them at this point, so we won't be calling them quite yet. Okay, so like I said, I gotta go do some paperwork, they're gonna chat, with some people, and then we're gonna come back and talk to you if you're okay with that. So just give us a little bit more time, like I said, and you go and do that.
So, like, you guys tell his family, like, today or after tomorrow? You have to.
Once our investigation is pretty much complete here, once we leave here, we will be going to.
But again, we'll know, I'm not gonna just go into it without you knowing, you'll know. Talk to you about it, anything like that.
But how, I mean, I understand what you guys and how you do it, and, you know, so, but like, what are you just telling us? What do you tell his parents? Like, what's the reason as to why?
We tell them what we know about them. We tell them the truth.
And that we're gonna be waiting for the autopsy results, and I will get the autopsy in the morning, and hopefully the doctor will be able to give me some of what they think and see.
Give them their number, they can contact them, get, you know.
So yeah, they're gonna know what we're here, what we're investigating, and that was so.
They're gonna think I failed him. They always have said that. They've always have said that. I told you it's because I'm the blue-eyed white dragon, that's what they call me. Because they don't want him with me. So he's basically just not really been around his family because he chooses me over them. Even after I encouraged him numerous times to go there and see his family.
Do you have somewhere safe that you can go tonight?
Both my parents are deceased, my grandparents are deceased, my aunt and uncle are deceased. I got notice. I have a brother that's in the Marines, and I've got another one that's in jail.
Unless the brother that's Marine local?
No. Well, he's in Altamont, but I think he's doing whatever Marine he's doing. But the only way.
Your phone's inside, correct?
Yes.
Does he have a phone?
No.
He does not. He used my phone. He uses your phone.
Yeah,
The share phone.
So the only place I could go is over to Brian's house. So I don't think I have a problem with it. So,
Well, like I said, we're not gonna leave here. If you do not feel safe, you're not gonna leave here if you're not feeling safe. And then we're like,
and then so I in Philadelphia.
well, she's in Philadelphia, because
There's gonna be a funeral.
right? That you're talking like days and no, I'm talking right here, right now. So let me do my investigation. Let me go do this paperwork that I'm talking about, because we can go back and forth about what it's like all day long.
I know. So
I promise we're not gonna leave here for you and you not feel safe. Right? Please.
I don't even know what to tell you.
It's okay. Just take a seat, have some water, give us a few minutes, let us do our thing, and we'll be back to talk to you, I promise, okay?
Let them know.
Good. Thank you.
Yeah.
Thank you.
Well, yeah. Okay.
You have anyone in there?
There's nobody here, just me.
Okay, that's fine. You're right there, right?
Yeah.
Sit there, take your time. I have relief coming, so just wait.
Please tell me that's the last one. Hello, baby. Hello. Hello.
No further questions.
Thank you. Any cross-examination?
No, sir.
Can this witness be released?
Mm.
Yes.
Thank you, sir. You're released, not subject to recall. Thank you.
Thank you.
State, you may call your next witness.
State would call Melissa Roughgarden.
Melissa Rothgarden. Yep, I've got it. Oh, I've got the worst pain in the stomach. Mm. 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 So this is evidence collection.
Ma'am, good afternoon. Can you state and spell your name for the record for us?
Melissa Roughgarden, Melissa Roughgarden.
Thank you. Counselor, you may inquire.
Ma'am, who do you work for?
I'm employed with the Orange County Sheriff's Office.
What is your position with the Orange County Sheriff's Office?
Currently, I am a forensic biologist with the forensics unit. Prior to this, I was a crime scene investigator for 5 years.
And how long in total have you been with the Orange County Sheriff's Office?
About 6.5 years.
And tell us all the positions you've held during that time.
Those two, a crime scene investigator and a forensic biologist.
Let's turn to your work as a crime scene investigator. What does a crime scene investigator do?
We respond to crime scenes. We photograph and document those crime scenes through photographs, notes, and sometimes sketches. We collect evidence, we process the scene, and then we do further processing to that evidence back at our forensics lab.
When you say process evidence or process the scene, can you tell us what that entails?
It depends on the scene and the evidence, but it includes the photographs. We also take swabs for potential DNA. We can also do testing for possible blood and things like that. We also process for latent fingerprints, among other things.
What type of training did you need in order to become a crime scene investigator?
Upon being hired with the sheriff's office, as a CSI, I completed a 16-week training program, which includes in-house processing, as well as going out to crime scenes with trained crime scene investigators to observe and then assist, as well as taking on calls with the trained crime scene investigator.
Approximately how many crime scenes have you processed in the course of your time as a CSI?
It would be hundreds. I don't know the exact amount.
Were you working in this capacity as a CSI on February 24th, 2020?
Yes, I was.
And tell us, where did you respond out to on that day?
I responded to 4748 Franz Court, apartment 3.
And is that in Orange County, Florida?
Yes, it is.
And when you responded to that scene, whom did you make contact with?
I made contact with the homicide detective, Chelsea Kepsel.
Did you receive information from the detective?
Yes, that it was a death investigation.
Did you walk the scene with the detective?
Yes.
And tell us, what does it mean to walk the scene with the detective in a homicide?
We go into the scene and just observe. We don't interact with anything and discuss what we see.
When you walked this scene, did you see Jorge Torres?
Yes, I did.
Where was he located?
He was located on the floor in the living room of the apartment.
Did you, with the detective, identify potential items of evidence to be collected?
Yes.
You had mentioned previously about documenting scenes with photographs. Was that done in this case?
Yes, it was.
Your Honor, may I approach the witness who's been marked for identification as States M and been shown to defense?
Okay.
Ma'am, I'm showing you what's been marked for identification as States M. Can you take a look at the contents of State M to yourself and tell me if you recognize the items contained within States M?
Yes.
Do you recognize the contents of States M?
Yes, I do.
Tell us, what is the contents of State M?
They are photographs I took on the crime scene.
Do they fairly and accurately represent how that crime scene appeared on February 24th, 2020?
Yes, they do.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States M into evidence.
How many photographs are there? Do you have a total?
111.
No objection.
All right. What was pre-marked as States M will be received into evidence without objection as States 8.
Your Honor, request permission to publish.
You may.
Your Honor, could we have the lights dimmed?
Yes.
And I'm first going to publish to you as part of States M picture photo number 4. Tell us, what is this?
This is the front door to the residence.
States 5.
This is also the front door of the residence, just a closer image to the door.
When you enter the residence, what is the first area just off to the right of the front door?
That would be the kitchen.
Showing you it's been marked as States 11.
Yes, so this is just inside the door. To the right, there is the kitchen area.
Showing you States 14.
Yes.
What is this a photo of?
So this is the counter with the sink in the kitchen. And there's also the open area just above where you can see into the living room.
Showing you from States Composite, photo 19.
Yes.
What is this?
This is a hutch inside the kitchen. You can see in the background, that is where that first photo of the kitchen was taken. So that's the entryway. And then this is the hutch, and there is a cell phone on the hutch in the kitchen.
showing you statement 22.
This is the trash can in the kitchen. You can also see the hutch we were just looking at there on the side.
I'm sorry. These stomach ache. No, what's the?
States 23.
This is the contents of the trash can. You can see 2 wine bottles on the top of the trash.
Did you also find receipts in that trash can as well?
Yes.
So sorry. Something's upset my stomach.
Photo 25.
These are those same wine bottles and 3 Publix receipts that were removed from the trash can.
Did you take these items and collect them into evidence in this case?
Yes, I did.
Photo 32 from the composite.
Yes, this is just in further into that entryway. You can see the living room.
Photo 35 from the composite.
This is another photo of the living room. You can see the victim located on the floor and a suitcase in the bottom corner of the photograph.
Photo 36.
This is another photograph in the living room. This is that wall we saw in the kitchen there with the opening. You can also see a wooden baseball bat leaning against the wall.
Is that baseball bat collected into evidence in this case?
Yes, it was.
Photo 38.
This is, excuse me. This is also a photograph of the living room, just the other side of the room.
Let me. Here you go.
Photo 43 from the composite.
Yes. This photograph was taken in the living room. You can see the stairs leading to the second floor.
This looks riveting too. Doesn't appear that I missed a great deal. Don't know what it is that I've eaten that give me.
This is a photograph of the living room just from the other side of the room. You can see the front door in the middle back of the photo.
Photo 49 from the composite.
This is a more close-up photograph of the suitcase.
Photo 50.
This is a photograph of one of the zippers on the suitcase.
It's okay, sweetheart. I've taken some tablets and hopefully that should settle it down.
This is a close-up picture
Thank
of that
you.
same zipper. There is no zipper
I've made it
pull
this
on
far.
it. It appeared to be a small wire of some sort, the pink wrapped around the zipper. This is the zipper on the other side of the suitcase.
Just for the record, that's photograph 52. States 53 from this composite.
The close-up image of that same zipper. There is also no zipper pull on that one.
Photo 54 from the composite.
This is the contents of the suitcase after just lifting the lid.
Photo 56 from the composite.
More of a close-up image of the items. There were miscellaneous papers and paperwork, some clothing items, and apparent blood inside the suitcase.
What items, what apparent blood was inside the suitcase?
It was observed on the white cap and a necktie, and there was also visible blood just on the interior of the suitcase.
Photo 57 from the composite.
The contents of the suitcase, but you can see the white cap more clearly and the blood observed on it.
'58 from the composite.
You can see the necktie with blood. It appeared to be silver multicolored. And then there's also a diazepam syringe in the plastic casing there. It was prescribed to the victim.
That's weird. Why would you have a Valium syringe?
Photo 61 from the composite.
That is the miscellaneous papers and paperwork that was removed from the suitcase.
Photo 62 from the composite.
That's the suitcase after all of the items were removed.
Photo 64 from the composite.
Yes, that is what appeared to be some like small pieces of paper that appeared to be soaked with blood.
Is this inside of the suitcase?
Yes.
Photo 65 from the composite.
That is the baseball bat that was leaning against the wall in the living room.
Photo 68 from the composite.
This is back to the stairs to the second floor in the living room.
Photo 69 from the composites.
This is moving closer
The dead
to
weight.
the stairs to the second floor.
Photo 70 from the composite.
photographing more of the staircase. These are the steps leading to the second floor before I proceed up to the second floor.
This is photo 71 for the record. Photo 72 from the composite.
The upper portion of the stairs leading to the second floor.
How many bedrooms were on the second floor of the unit?
There were 2 bedrooms.
Anxiety.
Photo 75 from the composite. What is this?
This is the hallway. You can see a closet in the hallway and then the door to one of the bedrooms.
Does this appear to be a child's room?
Yes, it did.
Photo 79 from the composite.
This is a photograph within the child's bedroom.
Photo 86 from the composite.
This is the door leading to the other bedroom upstairs.
Did this other bedroom also contain a bathroom?
Yes, it did.
Photo 90 from the composite.
This is the bed within that bedroom.
Photo 97 from the composite.
This is the bathroom.
In that master bedroom upstairs.
Yes.
Did you also have an occasion to photograph the defendant?
Yes, I did.
You see the defendant here in court today.
Yes, I do.
Could you please point to them and identify an article of clothing they're wearing?
She is right there with a black blazer and a pink shirt.
Your Honor, may the record reflect that the witnesses identified the defendant?
Record so reflect.
Showing you photo 98 from the composite.
This is the photograph I took of the defendant.
Why is it that you are photographing the defendant at this point?
I collected her buccal swabs, which is a DNA standard from the inside of the mouth, and it is part of our procedure to photograph that person for identification purposes.
Do you also document the rest of her body as well at that time?
Yes, I did.
Publishing photograph 101 from State's Composite.
This is a photograph of her hands facing upward.
Photograph Photograph 102.
This is her right hand facing upward.
Photograph 103.
Her left hand facing upward.
Photograph 104.
Both of her hands facing downward, so the tops of her hands.
Photograph 105.
This is her right hand facing downward.
Photograph 106.
And her left hand facing downward.
Photograph 107.
This would be of her right arm.
Photograph 108.
Her left arm.
Photograph 109.
Her right arm with it facing upward.
Photograph 110.
Her left arm with her arm facing upward.
During the time you were interacting with the defendant, did she ever indicate to you that she had any injuries?
No.
You had previously testified that you also collected physical items of evidence from the home as well in this case.
Yes, I did.
Your Honor, may I approach the witness what's been marked for identification as State C and been shown to defense?
You may.
Ma'am, I'm assuming it was remarked for identification as State C. Can you take a look at that package for me?
Yes.
Do you recognize that package?
Yes, I do.
And tell us, what is that package?
These are the 2 wine bottles that were collected from the trash can.
Is your name on that package?
Yes, my name is on the Orange County Sheriff's Office evidence label that I filled out, and my initials are on the evidence seal from when I sealed the package.
And it also has your agency case number and the location information for this case.
Yes, that is correct.
Ma'am, could you open the contents of States C and look at it to yourself?
Pull them out to recognize the item. They're wrapped in bubble wrap.
Sure, just how the view from before.
this is probably the most boring part of trials for me. The actual entering in of evidence. It's just so laborious.
What is the contents of states?
I know they have to do it.
These
but
are the 2 wine bottles that I collected from the trash can.
Are these wine bottles in the same or substantially the same condition as they were at the time that you packaged them on February 24th, 2020?
Yes, the same time I collected them that day.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states C into evidence.
Any objections?
No objection.
What was pre-marked as state C will be received into evidence as states 9 without objection.
And Your Honor, request permission to publish.
You may do so.
You can unwrap it now.
oh, that was easy.
You can flip it back. Did you also have occasion to collect the baseball bat from the living room?
Yes, I did.
Your Honor, may I approach the witness who has been previously marked for identification as states B and shown to defense?
You may.
Ma'am, I'm showing you it's been marked for identification as states B. Can you take a look at this item?
Yes.
Do you recognize this item?
Yes, I do. This is the wooden baseball bat I collected from the living room.
Does this item have your name on it?
Yes, it has my name on the Orange County Sheriff's Office evidence label that I filled out, as well as my initials on the evidence seal.
And it also has your initials and your agency case number as well.
Yes, it does.
Ma'am, could you open states B and look at the contents of it to yourself without displaying it to the court?
Yes.
What is contained within states B?
The wooden baseball bat.
And is that bat in the same or substantially the same condition as it was at the time that you collected it on February 24, 2020?
Yes, it is.
Your Honor, at this time, I'd like to move what's previously been marked for identification as States B into evidence.
Any objection?
No objection.
What was pre-marked as B will be received into evidence as States 10 without objection.
Your Honor, request permission to publish.
You may.
You also had an occasion to collect a suitcase as well in this case.
Yes, I did.
Prior to placing the suitcase into evidence, did you process it?
I took measurements of the suitcase.
What are the measurements of the suitcase?
It was 28 inches in length, 20 inches wide, and 8 7/8 inches deep.
Your Honor, at this time, may the witness step down from the stand and approach the clerk's area.
Yes.
Ma'am, I'm showing you what's been marked for identification as States A. Tell me, do you recognize this item?
Yes, I do.
Tell us, what is this item?
This is the suitcase I collected from the living room.
And how is it that you know that this is a suitcase you collected from the living room?
It has the Orange County Sheriff's Office evidence label that I labeled with the item description. It also contains my name and the agent's case number, and my initials are also on the evidence tape.
Ma'am, at this time, could you open States A and look at the contents of it to yourself?
Yes.
This must be the suitcase I'm tipping.
What is inside of States A?
This is the suitcase I collected from the living room.
It does appear to be the
What?
same or substantially
Who took
the
it off
same
my shelf?
condition as the time that you collected it and placed it into evidence?
Yes.
Your Honor, at this time, I'd like to move what's been marked for identification as States A into evidence.
Any objections?
No objection.
What was pre-marked as A will be received into evidence without objection as States 11.
And Your Honor, at this time, I ask for permission to publish States A to the jury.
You may.
Can you open the inside of it? how easy is it to operate the zipper that closes the suitcase?
It was a little difficult.
I have no additional questions at this time.
Thank you. Any cross-examination?
Yes, Your Honor. Good afternoon.
Good afternoon.
Are you also referred to as a medical examiner investigator as opposed to just crime scene investigator?
No, that is not my title.
Do you do reports that the crime or that the medical examiner necessarily relies upon in the process of doing the autopsy and additional investigations?
You would have to ask them.
Who makes the decision at the scene as to what items will be photographed and what items will be taken into custody, and what items will necessarily be tested or analyzed?
That's a collaborative effort between the crime scene investigator and the lead detective while on scene.
That would be yourself, and who was the lead detective?
The lead detective was Chelsea Kepsel.
Now, you authored a report in this matter, did you not?
Yes,
And that report was utilized, if you in fact know, by the medical examiner in developing her autopsy report, was it not?
I do not know.
In your report, did you advise the medical or whomever might read your report that in fact the body had been removed from the suitcase by first offenders or first responders?
No, I don't believe so.
And we know that you have the capacity to do DNA analysis, correct?
No, we process DNA or collect swabs for DNA, and then that's submitted to the Florida Department of Law Enforcement for conventional DNA analysis.
So you did that with a sample from the inside of Sarah Boone's mouth.
Her buccal swabs were submitted to the FDLE.
And who made that decision?
The detective and I.
Who made the decision not to bother to do a DNA analysis on the blood from the items within the suitcase or the suitcase itself?
That was a discussion between the detective and I.
And you chose not to do that.
No, we did not.
You assumed that the blood inside the suitcase belonged to Jorge Torres, correct?
There was blood observed in the suitcase.
But you don't know who that belonged to because you didn't bother to analyze it or have it analyzed, correct?
The blood was not tested.
Now, State's Exhibit B, the bat, you took that into evidence. Was that again a collaborative decision by yourself and the lead detective?
Yes.
And what efforts did you make to have the bat analyzed, given the fact that it was apparently evidence?
It was just collected as evidence from the scene.
Did you advise either the lead detective or anybody else involved with this investigation that there may be matters that could be analyzed when analyzing the bat that would help or assist in the investigation of this matter?
It's my job to do the documentation and the collection of evidence.
Well, you said it was a collaborative effort between yourself and the lead detective, so did you participate in that decision?
We chose to collect the bat and put it into evidence.
And so there was a fiber analysis done on the bat to determine whether or not it was used to strike Jorge Torres when he was in the suitcase. Was there not?
Pardon?
In fact, there was not, was there? There was no effort to analyze the bat.
Jack, I don't believe the witness had an opportunity to answer the question.
Sustained.
I'm sorry. Please.
Can you repeat the question?
If I can remember it, I will. Do you know that there was any effort made in this particular investigation, the investigation of Sarah Boone, to analyze the bat for fibers?
No, there was not.
And why was that not done?
It was not done.
You indicated that you had some interaction with Ms. Boone, is that correct?
I collected her buccal swabs.
Did you speak with her?
In collecting her buccal swabs, yes.
Did you speak to any other witnesses?
No.
Did you make any determination of other matters that might be of import or evidentiary value when you were going through the house and taking photographs and documenting the
I had a
interior of the
feeling
townhouse.
this will be
You'll
our
have to
last,
be more
last
specific.
witness for the day.
How many pictures of the child's bedroom did we see?
Just quietly.
Here today,
Yes, ma'am.
we saw the entrance to the bedroom as well as a photograph of the interior of the bedroom.
What was the evidentiary value of that?
It's my job to photograph and document while on scene, so the rooms in the upstairs were photographed and documented.
Did you photograph holes in the wall, possibly made by the victim?
I don't recall photographing holes in the wall, no.
Did you take photographs of items within the house or throughout the house that may have depicted incidents of prior violence?
You'll have to be more specific.
How about bloody pillowcases? Did you make any effort to collect and analyze pillowcases of the rooms that you were photographing?
No.
Who made, you have significant experience with zippers?
I use zippers regularly, yes.
He is
Enough
a forensic
to have an
collection.
opinion as to whether or not
It's not her
a
scope
zipper is stuck or not.
of expertise.
Is what? Sorry?
You testified on direct that the zipper was a little tight.
Just that it was difficult without the zipper pulls to use the zipper.
And that was your opinion.
Yes, from opening the suitcase here today.
Today, you only tested it today?
Pardon?
You only today have for the first time tested the ability to pull open the zipper on the suitcase?
No, I'm saying it was difficult today.
A redirect examination.
Yes, Your Honor. In this case, you documented the entirety of the house as you saw it.
Yes,
So every room in the house,
they were all taken overall photographs.
walls in the house.
In the overall photographs, yes, they weren't all individually photographed, no.
And you did not document or note any type of holes in the wall or any type of damage to the walls, anything like that.
Not the walls, no.
Is that something that would have been documented both photographically and also within your report?
Yes,
You also, as we've previously seen in the composite, saw the victim where he was laying in this case, correct?
yes,
Was the victim, did he have blood on his mouth and on his face?
yes, he did.
Did he have open wounds on his body?
There was blood
at you,
coming from
baby.
his
Back
nose
at
and
ya.
his mouth. There was also some other areas
I'm the same.
like defects noted on his body.
You also made contact with the defendant too, as well.
Yes,
Did you note any other wounds or cuts or anything else
What are you having for dinner?
that was not documented that
Yummy.
you haven't testified to?
no,
So no wounds, nothing on her.
not that I recall, no.
No further questions.
Thank you. Can this witness be released?
Yes, Your Honor.
Mr. Owens, can this witness be released?
7 minutes, I reckon they're going to wind it up.
Subject to recall, ma'am. Thank you.
Of course, subject to recall. They're going to do that to every witness. Just in case, and to keep them
Can the parties approach?
sequestered so that they have to stay quiet and cannot talk to anyone about it. That's why. So what are you having for dinner, Tricia? Something yummy? I made chicken and sweet corn soup. So I was a bit of a piggy. I had 2 bowls. It was yum. And I've had my strawberries and mango and yogurt and maybe a couple of killer python snakes, which were absolutely necessary to get me through.
Members of the jury, thank you so much for your
Oh,
attention on this
yeah.
matter. It is 4:52. At this
Yeah.
time, we're going to go ahead and take our recess for the evening.
Yep. Thought so.
Madam Clerk has letters that I have signed regarding your jury service for you to provide to your employer. Court deputy will provide them to you in the deliberation room before you are released for the day. I have a similar instruction to read to you that I gave you before
So,
the lunch hour.
how many?
Jurors, you must not conduct any investigation on your own. This includes reading
1,
newspapers,
2,
watching
3,
television,
4,
or
5,
using a
7,
computer,
8,
cell phone, the
9,
internet,
10.
any electronic device, or any other
Oh.
means at all to get information related to this case or the people and places involved in this case. This applies whether you are
It's we've gotten through 10 out of the 23 listed. So I don't know. I might do a bit of a deep dive. Might have a look over the weekend and see actually how many they have on the list. Because they're moving through them fairly quickly, which is good.
in the courthouse, at home, or any fellow jurors about the case must not touch their electronic devices to communicate.
All
Do
right.
not send or
Assuming
accept
9
any
a.m.
messages
Monday.
related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog.
Oh,
With that, members
but
of the
they
jury,
come
we'll
over and
release you back
watch.
to the deliberation room for you to receive the paperwork for your employer, and we will see you at 9 a.m. this coming Monday,
There you
October
go.
21st. I thank you for your sacrifice and your service.
Wow. It's underway, folks. Completed day 1 successfully. And it was over. Do, 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 do. Before it began. All right. So let me get back to hoot. And let me stop that. All right. Well, day 1 down. Day 2 on the way. And yeah, let's hope that my theory is incorrect. If you've just popped in, go back to the very, very start of the stream and have a listen to see what my prediction is as far as the defence's strategy. And the more that I'm watching this, the more merit I think that it possibly could have, unfortunately. But time will tell. So again, thank you very much for joining me. I will be sleep streaming the burnt husband trial shortly. I'll put that on. Well, what's that for? What's that for? Who's the dude? What have they done? Or was that meant for someone else? All right, my lovelies. You have yourself an awesome Friday night, Friday evening, Friday, Saturday morning, Saturday, wherever thou shalt be. I'm going to bed and I shall catch you all. As I said, I'll be streaming the, once I've left here, I'll be putting up the burnt husband one, but it'll be just a sleep stream, so I won't be commentating. So you won't be interrupted. You have it in peace and quiet. And yeah, because we're up to day 10 on that one. And yeah, Monday we'll be back with Ms. Boone. All right. Thank you again. With that, hasta la vista, adios, and see when I'm looking at you. Bye-bye.
Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests. Justice served in an honest fight. crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule and the defense rests.